matter.
Fresh matters.
Final hearing. Final hearing.
Yes.
The respondents are old age persons, sir. Respondents are old age persons in the RFN matter, sir. Recent, she was an Anganwadi teacher. Recently, she was.
There is any urgency, you'll have to file application for early hearing. Otherwise, it will come in the normal course. Yes.
Well, yeah, usual. Yeah, usual course.
Yes.
Mission is to come. Non-compliance of office objection.
Submission. This matter is covered by Development Authority, Shailendra. You got the respondent number 1 died. I have filed application to bring LRs. And notice is issued. And will kindly be posted for hearing on the LR petition.
On IA.
On representation, LRs. On LR's application.
Ian, what is the urgency?
My lord, this matter is pending since
You have filed
2017.
an IA.
I am appellant. This matter is pending since 2017. And all the development of APMC is standstill.
Yes.
So therefore, my humble solution, the Honorable Court, that the application may kindly be heard and pass the order, and the matter will go for final hearing.
So matters to come up for hearing on IA, isn't it?
Yes, sir. That is for
What do you know? Let us see. Yes.
another application.
Yes.
Office objection for first time, CL number 1, additional government.
Beg, sir.
So this matter is covered by Vinita Sharma.
Matters will not come. If there is any urgency, you will file application for early hearing. Otherwise, it will not.
Early hearing has filed
Yes.
your honor.
Hakidira.
Early hearing hakidis.
Yes.
CL number 1.
55, my lord. 55. I have for respond, my lord, sir. Request for a week's time.
The other side is not here. We will not adjourn the matter now. Please wait till the matter reaches.
Yes, not seen.
Yes.
CL number 1, additional government advocate, CL number 1.
Yes, sir. 2 weeks time, my lord.
2 weeks are granted at the request of the learned government advocate for complaints of office objections.
CL number 2, Veerangoda Mali Patil.
Weeks time.
Week's time. 4th time. Finally, a week's time is granted at the request of learned counsel for the appellant for complaints of office objections. 2, 3, 4.
Please.
CL number 5, RJ Busare.
Weeks accommodation, my lord.
Same. Finally.
Please.
CL number 6, Ganesh Subhash Chandra Kalaburagi.
Here, this matter was posted before the Honorable Single Judge. Due to change.
2 weeks are granted at the request of learned counsel for the appellant for complaints of office objections.
Much.
CL number 7, Chaitanya Kumar Chaliki.
Kindly 1 week time may be granted.
A week's time is granted.
CL number 8, government advocate.
2 weeks finally, lots of grant, my lord.
2 weeks finally at the request of learned government. Yes.
Orders, serial number 9, additional SPP.
On receipt of police report. LA additional SPP. Allah, additional SPP. Sorry.
Report.
Pass over. 9, 10. Third police report. Other police report. 9 or 10. Pass over.
Serial number 11.
I appear
Siddhartha
for the
P.
petitioner's
Desai.
lordship. This IA was filed during the COVID. Therefore, that we had not filed a condonation of delay. I had filed a memo on 19/9 saying that due to the Supreme Court's order, delay application was not required. However, officers raised objection. This matter was dismissed for non-prosecution during the COVID. I had filed application to recall.
Second set to Akil until Ray. Second set to Akil Anivo.
I'll comply with the objection.
A week's time is granted at the request of learned counsel for petitioner for complaints of office objections.
Grateful.
Serial number 12. Shivanand Patil. Serial number 12.
Finally, 2 weeks are granted to the appellant to furnish paper books.
CL number 13, Hema L. Kulkarni.
This is the matter, my lord.
The date before yesterday matter.
On other side made the submission that my lord, review petition pending ide anta. That is not the review petition.
Huh?
Review petition, this is the content matter, my lord, supermarket matter, my lord. Other day, my learned friend made the submission that review petition pending ide.
Idena.
ಹೌದು review petition ಅಲ್ಲ writ appeal pending.
ಇದರಲ್ಲಿ ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಅಲ್ರಿ ರಿಟ್ ಅಪೀಲ್ ಪೆಂಡಿಂಗ್.
ನಾನು ಅರ್ಲಿಯರ್ ಒಂದು ಜಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೆ ಸ್ವಾಮಿ, ರಿಟ್ ಅಪೀಲ್ ಜಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೆ, ಅದ್ರ ಮೇಲೆ ರಿವ್ಯೂ ಹಾಕಿದ್ದಾರೆ ಅಂತ. ಅದನ್ನೇ ರಿಟ್ ಪಿಟಿಷನ್ ಸೇಮ್ ಕನ್ಸಲ್ಟ್
ಅಲ್ರಿ ಇದ್ರ ಮೇಲೆ ರಿಟ್ ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಿದಾರೆ, ಅದು ಪೆಂಡಿಂಗ್ ಇದೆ,
Pending ಇದೆ.
ನಾಟ್ ರಿವ್ಯೂ ಪಿಟಿಷನ್.
maybe connect and post. And yesterday similar matter mailers posted for hearing before charge mailership. This case is also posted.
ಓ ಇದು ಅದರದೇನಾ?
Same similar matter.
Same, ಅದು
Totally
you
7
dismissed
plots
the
are
writ
there,
appeal, my
mailers.
lord.
There are totally 7 plots mailers. The one of the same similar case. 7 plots ಕೂಡ ಒಂದೇ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ದಾರೆ, ರೆಸೊಲ್ಯೂಷನ್ ಪಾಸ್ ಮಾಡಿದ್ದಾರೆ.
Then same order.
Same order.
Whatever we have passed will apply in this
That's why,
matter.
Lord, that writ appeal has to be posted along with this, my lord.
Huh?
Writ appeal has to be posted along with this, my lord.
ಬರ್ಕೊಳ್ಳಿ.
What's up any date?
ಯಾವ್ದು ರಿಟ್ ಅಪೀಲ್ ನಂಬರ್? On the previous occasion, it was submitted that a review petition filed at the hands of the respondents is pending consideration. Full stop. However, it is not a review petition, comma, it is a writ appeal that is pending consideration in WA number 200248 of 2024. Full stop. Next para. Release this matter along with writ appeal number so and so on 6th of November.
Please.
Please. Writ appeal FR, my lord. That is FR, my lord.
Huh?
Writ appeal FR, my lord.
Please.
Yes.
CL number 14, Ravi B. Patil.
In this matter also, my lord, we filed the writ appeal, my lord.
Hmm.
That is pending, my lord. Lordship direct the office to put up along with this. See, the kodi.
ಯಾವ್ದು?
200243 of
Matter
2020.
along with the writ appeal number
200243 of 2024. my lord.
on 7th of November. 7th of November.
Please.
CL number 15, Dear
I,
Kalaburagi Dostan.
Malad.
Needful done, my lords. Morning, clear the process. Learned counsel for the appellate submits that the needful has been done. Full stop. Office to verify and issue notice to the respondents. Please.
CL number 16, Ratna N. Shivayogi.
For the, kindly needful done, my lord.
Huh?
Needful is done. R1 to R5, I take step.
Needful done regarding office objection.
Yes, my lord.
ಏನ್ ಮಾಡಿದೀರಾ ಕೊಡಿ.
ಅದೇ process
ಪ್ರೋಸೆಸ್ ಅಲ್ಲ ರೀ, ಸೀರಿಯಲ್ ನಂಬರ್ 17 ತಾನೇ ಇದು?
16, my lord.
16 ಪ್ಲೀಸ್. ಹಾ, ಸೇಮ್ ಆರ್ಡರ್.
Okay.
CL number 17, KM Ghate.
Appearing for privator.
Office objection with regard to annexure U, my lord. Typed copy. Time being it may kindly be.
Type copy of annexure U.
Yes, ma'am. The joining letter to the service, my lord. Time being it may kindly be dispensed. Page 74.
Office objection is overruled.
Lord, the appointment of appellate hearing is quashed. my lord.
Notice was already issued, is it?
No, my lord, I'm
Cav-
appearing as
caveat,
privator.
Yes,
Privator.
caveat, my lord.
Ah,
Respondents 1 state, my lord, 2 and 3. Mr. Ravi Patil appears, my lord, who is standing counsel for the medical college.
Government advocate takes notice for
Respond number one.
respond number 1.
2 and 3, Ravi B. Patil.
Learned counsel. Huh?
Ravi B. Patil. 2 and 3.
For brims.
The Ravi B. Patil is requested to take notice for respond number 2 and
2 and 3.
Learned counsel Shri Sharana Basappa M. Patil has entered appearance for respond number 4. Learned counsel for the appellant is directed to serve copies of the appeal memo along with annexures on the learned government advocate and learned counsel for response number 2 and 3.
Please.
Ah.
I seek for stay of the matter.
Yen state.
Appointment. My lord. Appointment. 2017 appointment was there, my lord, as a clinical pathologist clinical post that is being quashed by the learned single judge. And meanwhile, during pendency of the writ petition, his probation was already declared. I request to produce the document, my lord, that probation period was declared during pendency of the writ petition.
Fourth respondent was appointed
Please.
as clinical psychologist.
May I produce the documents?
Yeah.
During pendency of the writ petition, his probation was declared, and he was also had a degree of this PhD degree, and also experience certificate which was issued by the respondents 2 and 3. What happened here, my lord? He was serving as a temporary employee from 2013, my lord. 2017 notification came to be issued, and thereby he applied, my lord. And as per the notification issued, the qualification was only the MA or MSc psychology, the clinical, that was the only requirement. There was no requirement with regard to PhD or any gold medal certificate, my lord. My respectful submission, my lord, the learned single judge, by considering the document produced by the fourth respondent that she hold PhD degree and gold medalist, the order of the appellant herein was quashed. So I submit, my lord, the selection committee had a powers to assign the marks while in walk-in interview, my lord. So that powers of the selection committee is being disturbed by the learned single judge. As per the apex court, my lord, selection committee powers to assign the marks in walk-in interview, my lord. In the case of Tajveer Singh, I am relying on that ruling.
You were the respondent there.
Yes, I was the
before the learned
respondent.
single judge.
Yes.
So you are seeking to produce some documents now.
Please.
All right. You please give it to them. We'll see.
I've given the copy the other side.
List this matter, release this matter on 11th of November. No, not here.
I will produce it.
Yes.
Serial number 18, Mahesh Patil.
This is yesterday's matter, my lord.
Hmm.
This is regarding posting to the, my lord, petitioner. But he
Huh?
is ready regarding giving the posting, my lord. He is not having any post, my lord. That's why lordship directed me to get the instruction.
Yes.
But today we are passing the order, giving the posting to him, my lord.
Ah.
Lordship, have it on Monday, my lord, will produce it.
Learned government advocate submits on instructions that postings will be given to the petitioner in a day or two. Full stop. Release this matter on 28th of October.
Please.
Serial number 19, hearing on IA, Sharan Basappa K. Bob Chetty.
Appellant in this case, my lord.
Huh?
In this case, my lord, I have filed additional documents, my lord, before this honorable court. But my lord, there is office objection in the IA, additional document. The index I have, oversight, I have not filled the index, my lord, and pagination, my lord. I have to. We've taken next week, my lord, I will.
A week's time is granted at the request of learned counsel for the appellant for complaints of office objections raised on the interrogatory application. Yes.
Serial number 20, government advocate.
There is a delay, my lord. Notice may be issued.
Issue notice to the respondents on IA number 1 of 2021.
Please.
Serial number 21, Vishal Pratap Singh.
Lords, and may it please the court. Now here, I'm seeking, an application is filed seeking suspension of sentence and grant of bail, Lords. I have also filed an application under section 391(1) of CRPC, where I filed an additional evidence also to dismantle and disprove the case of the prosecution and to further support the IA for suspension of sentence. Lords, the order of conviction passed by the session court is patently illegal because it deviates from the settled position of law and fails to appreciate the evidence in right perspective. Admittedly, my lords, in this case, there are no eyewitnesses in this case. The case rests squarely on the shoulders of circumstances. My lords, it is a settled position of law that the cases where the order of conviction is to be entered on the basis of circumstantial evidence, then the prosecution is saddled with the burden to establish a chain of circumstance, my lords, which begins with the motive and ends with the singularity of guilt. Because there are no eyewitnesses in the case, so that Panchashila judgment would come into play. To establish the motive, my lords, the prosecution in this case had come up with a story. They have come up with the prosecution, my lords. The first thing they did before the trial court is to destroy the standing of this appellant by saying that this appellant, who is before this court, my lords, was an alcoholic, was a gambler, and therefore was under financial debt. Because he was under that debt. And second thing they did was they built the first story and say that because he was under debt, he started demanding money from his wife, and his wife refused to provide him money. Consequently, the relationship between the deceased woman and the husband had strained and turned dangerously toxic. And therefore, the appellant, in order to get rid of her, murdered her. That is the story presented by the prosecution. This, according to prosecution, is the motive, that strained relationship. Now, my lords, I will establish that prosecution has failed to establish the motive because the motive is on the pillar of which the case of prosecution is rests. My lords, firstly, I will take a lordship to the complaint of this thing. Very briefly, I will just read the complaint. That itself would satisfy this court. The complaint is filed by the mother of the deceased. This is a paper book he has prepared, my lords. In the paper book itself, your lordship can see, which is on page 5. Page 5 will exhibit P34 is the complaint. Ali, ಅವಳು ಹೇಳ್ತಾಳೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟವರು, ನನ್ನ ಮಗಳಾದ ಶ್ಯಾಮಲಾಬಾಯಿ ಗಂಡ ಬಸವರಾಜ್ ಕಟ್ಟಿಮನಿ ಇಸ್ ದ ಅಪೆಲೆಂಟ್ ಹಿಯರ್. ಇವಳಿಗೆ ಅತ್ಯಾಚಾರ ಮಾಡಿ ಕೊಲೆ ಮಾಡಿದವರ ಮೇಲೆ ಕಾನೂನು ಕ್ರಮ ಜರುಗಿಸುವ ಬಗ್ಗೆ ಅರ್ಜಿ. ಮಾನ್ಯರೇ, ನಾನು ನಿನ್ನಮ್ಮ ಗಂಡ ಮರೆಪ್ಪ ಬುದಿ, ವಯಸ್ಸು 55, ಜಾತಿ ತಳವಾರ್, ಹೊಲ ಮನೆ ಕೆಲಸ ಮಾಡ್ಕೊಂಡು ಬದುಕ್ತಿದ್ದು. ಈ ಮೂಲಕ ನನಗೆ 3 ಜನ ಗಂಡು ಮಕ್ಕಳು 2 ಹೆಣ್ಣು ಮಕ್ಕಳು ಇದ್ದು, ಅದರಲ್ಲಿ ಶ್ಯಾಮಲಾಬಾಯಿ ಹಿರಿಯ ಮಗಳಿದ್ದು. ಅವಳಿಗೆ ಸುಮಾರು 20 ವರ್ಷಗಳ ಹಿಂದೆ, ಅಂದ್ರೆ ದೇ ಮ್ಯಾರಿಡ್ ಫಾರ್ 20 years. ಹಿಂದೆ ಬಂದರವಾಡ ಗ್ರಾಮ ಬಸವರಾಜ್ ತಂದೆ ಹಿರಿಗಪ್ಪ ಕಟ್ನಿ ಇವರೊಂದಿಗೆ ಮದುವೆ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದು. ಸದ್ಯ ನನ್ನ ಮಗಳಿಗೆ ವೀರೇಶ್ 19, ಮಹೇಶ್ 16 ಮತ್ತು ಭಾಗ್ಯಶ್ರೀ ಅಂತ ಮಗಳು 17 ವರ್ಷ. ನನ್ನ ಮಗಳು ಗಂಡ ಮಕ್ಕಳೊಂದಿಗೆ ಹೊಲ ಮನೆ ಕೆಲಸ ಮಾಡಿಕೊಂಡು ಸಂತೋಷದಿಂದ ಇರುತ್ತಾಳೆ. This is very, very important. This woman on the date of complaint saying that from 20 years my daughter was married, she is having 3 grown-up children and she was living happily. So my lords, the question of strained relationship absolutely doesn't arise. If you see the title of Vishaya, the body was found in a village, in a land, in such a state where it appears either she was raped or there was an attempt to rape. In such state of affairs, the body was found and then her head was smashed. And this particular, and come, if you see the next page, my lords, last page, the next, ಅಲ್ಲಿ ಇವರ ಪಾಲಿಕೆ ಮಾಡಿದ ಮಹಾದೇವಪ್ಪ ಹೊಲದಲ್ಲಿ I am reading on the, I am continuation. ಲಕ್ಷ್ಮೀ ಭೂದಿತನ ಫೋನ್ ಮಾಡಿ ಹೇಳಿದ್ದೇನೆಂದ್ರೆ ಅಲ್ಲಿ I am reading the first line. ಇವರ ಪಾಲಿಗೆ ಮಾಡಿದ ಮಹಾದೇವಪ್ಪ ಹಾಲಿಯವರ ಹೊಲದಲ್ಲಿ ಶ್ಯಾಮಲಾಬಾಯಿ ಅಕ್ಕ ಇವರು ಗೋಧಿ ಬೆಳೆಗೆ ನೀರು ಬಿಡಲು ಹೋದಾಗ ಯಾರೋ ದುಷ್ಕರ್ಮಿಗಳು ಅವರ ಮೈ ಮೇಲಿನ ಬಟ್ಟೆ ಬಿಚ್ಚಿ ಅತ್ಯಾಚಾರ ಮಾಡಿ ಮುಖ ಮತ್ತು ತಲೆಯ ಮೇಲೆ ಕಲ್ಲು ಎತ್ತಿ ಹಾಕಿ ಕೊಲೆ ಮಾಡಿರ್ತಾರೆ ಅಂತ ಹೇಳಿದ್ರಿಂದ ನಾನು ನನ್ನ ಗಂಡ ಮರೆಪ್ಪ ಮಕ್ಕಳಾದ ಭೀಮಾಶಂಕರ ಶಿವಪ್ಪ ಶರಣಬಸು ಕೂಡಿ ಬಂದರವಾಡ ಗ್ರಾಮದ ಮಹಾದೇವಪ್ಪ ಹಾಲಿಯವರ ಹೊಲದಲ್ಲಿ ಬಂದು ನೋಡಲಾಗಿ ನನ್ನ ಮಗಳ ಮೈ ಮೇಲಿನ ಅರ್ಧಂಬರ್ಧ ಬಟ್ಟೆ ಬಿಚ್ಚಿ ತಲೆಯ ಮೇಲೆ ಕಲ್ಲು ಎತ್ತಿ ಹಾಕಿ ಮಾಡಿದ್ದು ಇತ್ತು. ಅಲ್ಲಿ ಹಾಜರಿದ್ದ ನನ್ನ ಅಳಿಯ ಬಸವರಾಜ್ ಕಟ್ಟಿಮನಿ. ಸೊ ದ ಅಳಿಯ ವಾಸ್ ಆಲ್ಸೋ ಪ್ರೆಸೆಂಟ್ ದೇರ್. ಕಟ್ಟಿಮನಿ, ವೀರೇಶ್, ಮಹೇಶ್ ಸಂಬಂಧಿಕರು ಕರಬಸಪ್ಪ, ವಿನಾಯಕ್, ಅಲ್ಲೂರ್ ಇವರು ಹಾಜರಿದ್ದು ವಿಚಾರಿಸಲಾಗಿ ನನ್ನ ಮಗಳು ಬೆಳಿಗ್ಗೆ 10 ಗಂಟೆಗೆ ಹಿಂಗ್ ಹೋಗಿದ್ದಾಳೆ, ಅಲ್ಲಿ ಏನೋ ಯಾರು ಈ ತರ ಮಾಡಿದ್ದಾರೆ ಅಂತ. ದಿಸ್ ಇಸ್ ದ ಕಂಪ್ಲೇಂಟ್ my lords. Subsequently, prosecution, instead of investigating who has committed this offense, they have turned the entire case into saying, projecting that appellant was a alcoholic gambler and there was a strained relationship. As a result of it, he has committed the murder anta avaru madidare, which is absolutely, this has no foundation. The other document which I have produced before your court as an additional evidence, that additional evidence is nothing but the bank statement of Basavaraj Kattimani, the appellant. And in his statement, it is very clearly showing that he had sufficient money by selling his sugarcane crop to factory. And through that, he has received a lot of money and he was in the process of receiving some money also. Prior to incident also, he had money in his bank account. During the incident also, he had some money. And subsequently also, he had received a lot of money. So question of he being in debt doesn't absolutely arise. This statement was given by the son of the appellant itself. Sir, nodi ee tara nanna tande madidare. Why didn't you produce there? He said, I was not aware. So now, my lords, because motive plays a very important role, I have to first discard the motive here. And here I have produced that evidence under that application showing this honorable court that insofar as the debt is concerned, absolutely there was no such problem. And moreover, my lords, somebody would not ask his wife to give the money. And this is a case where somebody has tried to take her, rob her, what do you say? They tried to rape her and in the process, whether they succeeded or not succeeded, post-mortem report says rape has not taken place, but definitely an attempt was made and stone was smashed and she was killed. And my lords, no eyewitness in this case. So motive is gone. And the only basis upon which the conviction was entered is, according to prosecution, there is an extrajudicial confession by this appellant to one person in the village saying that, see, look, go and see whether people have assembled near my house. He says, why do you want me to go and see? You can directly go and see. No, I have murdered my wife. See whether these people have assembled there or no. Then he goes and sees, and then he says that, look, he has confessed before me saying that he has murdered his wife. But that person, before the trial court, has not supported the case of prosecution. So, my lords, even that also goes away. The extrajudicial confession also goes away before the trial court. He has not supported. So the very foundation, every aspect in the circumstantial evidence, each and every chain has to be established. Here, none of the chains are established. Only a preconceived notion that he was a gambler that prejudiced the court, and then they come to a conclusion that he has committed the offense and they convict him for life. So therefore, my lords, prima facie also no case is made out. Therefore, my lords, this is an appeal of the year 2023. Paper book is prepared. If your lordship are willing to take up for final hearing, I am ready for final hearing also. But if it is not going to come up, then kindly consider suspension of sentence and grant of bail. This is my prayer. And insofar as the legal position is concerned, although this judgment would help during the time of final hearing, but because this is a the Supreme Court judgment, 4-judge bench judgment, where the case pertaining to circumstantial evidence is very exhaustively dealt and discussed. Four-judge bench judgment of the Supreme Court.
When did the incident take place?
Incident has taken place, my lord, on 3/3/2022. And appellant was arrested on 14/3/2022. Initially, complaint was registered under section 302 and 376 rape. Insofar as, and prosecution is also alleging that there was a recovery at this place. The murder itself has happened because of the stone, and the stone was lying there itself. So, my lords, a recovery in criminal jurisprudence would be like, suppose if I have the exclusive knowledge about where I've done it, and if I take the police and show it, then it is recovery. If it is from the public place, it cannot by any stretch of imagination considered as recovery. So, recovery theory is also not gone. And insofar as last seen theory, nobody could come before the court and said that I have seen them last together. And even on last seen theory also, the criminal jurisprudence is very clear that it should have proximity with the murder. Suppose if somebody sees together, two people together in the night, if body is found in the morning, then it cannot be said that they are last seen theory, because there has to be some immediacy, some proximal time limit. That is also not there here. And very important judgment, which is most judgment, which would eliminate the law on circumstantial evidence, where four-judge bench, Justice B.R. Gawai headed this. Lord Justice Arun Kumar has authored this judgment. May I, with your permission, present? I will not read the whole thing, my lords. I'll just come to the last paragraph itself. Paragraph 37. Once again, my apologies, I have not numbered paragraph. Paragraph 37, which is on the last page. Last page,
37 or 27?
Paragraph 37. 37. Last page,
Yes.
Seen in this background, seen in this background, we need not go further and consider the evidence qua other circumstances sought to be proved by the prosecution, since the failure to prove a single circumstance cogently can cause a snap in the chain of circumstance. There cannot be a gap in the chain of circumstance. When conviction is to be based on circumstantial evidence solely, then there should not be any snap in the chain of circumstance. If there is a snap in the chain, the accused is entitled to benefit of doubt. If some of the circumstances in the chain can be explained by any other reasonable hypothesis, then also the accused is entitled to the benefit of doubt and the exhaustive. After going through everything, four-judge bench has come to the conclusion. So here, series of chains have snapped. One, the last seen theory is not there. Motive is not proved. Second, the complainant itself says for 20 years they are happily married and living. The third aspect, my lords, is with regard to my lords, the recovery, that is also not proved properly. The fourth, my lords, the person who says that extrajudicial confession itself is a doubtful picture in the overall scene. But even then, that person also has not come before the court and supported the case of prosecution. So in such a case, absolutely there was no ground for them to convict him. He has already spent 2 years in prison. And my lords, he is the one with the land. He has to take care of his land and agricultural land. He is also, so therefore, my lords, I carve out an exception. If lordship is willing to take a final hearing, I am ready to argue on final hearing also. But if
The only thing we'll have to consider is your additional document.
yes, additional document, additional evidence under 389. That also I have produced.
No, you are now seeking to produce it along with an application.
Application.
Therefore, it is not an evidence as of now.
As of now, it's not
That is why we said document.
document. My-
Huh?
ಹೌದು.
So, what do you say about this document?
My lords. Shall I brief on that?
Huh?
I'll brief on that.
Alala, we will give a date for considering the appeal on merits. What do you have to say about this document?
Documents which have been produced before the honorable court, my lords.
It's a bank statement.
Nothing was prevented the other side
I-
for producing
All right.
and
It was
leading
not
the
produced.
evidence to that particular
All right,
aspect.
it was not produced at that point of time.
Yes,
What is the difficulty in accepting this now?
of course, my lord. So I do agree that there is no bar at all. He can produce it. But my grievance is, my lords, the deceased
So
and
we-
accused own son and daughter.
We will consider the matter on appeal.
Yes,
We only wanted to know what would be your objection for this
Yes, yes, ma'am.
document. If you say, all right, let us consider this along with the main matter.
Yes.
We will hear the matter next week.
Please.
I'm good.
Huh? Because going by what is stated now, it doesn't look like there is a elaborate arguments required
Arguments are
in
not
this matter.
Elaborate.
We will
document
consider,
is-
we will consider.
Yes,
We are of the opinion that it can be disposed of. Appeal can be disposed
only
of.
my submission would be, my lord,
Yes.
the accused own son and daughter has supported the case.
Aye,
of the
Ade.
person. And I'll
The
elaborate
details,
to-
the details and your objections will
Yes.
be heard.
Yes,
List this matter for final hearing. On 7th of November,
7th of November will bring it.
11th or 13th.
Huh?
11th or 13th.
11th.
11th or 13th.
All right. ಆಯ್ತು. 11th of November.
13th at
Yes.
2:30 ಅಂತ ಮಾಡ್ಬಿಟ್ರೆ ಅವತ್ತು
ಹಾ?
11th it will be reached.
Reach ಆಗುತ್ತೆ.
I will do it.
Yes, yes.
I am grateful to your lordship.
Number 22.
Huh? Yes.
22, additional comment advocate.
In this matter, by mistake, my lord, we have not filed the IA for stay, my lord. You also grant 1 week time, my lord, we will file it this day. IA for stay, my lord.
At the request of the learned government advocate, release this matter on 5th of November.
Seal number 23, additional comment advocate.
This is, my lord, within 60 days, my lord, this IA for CD may be considered, my lord, and IA for stay as also may be considered.
Subject to deposit of 50%, my lord, and the permitted to withdraw the respondents, lord. In similar matters, Lordship.
Please give a copy of any other order first. Kodri,
kept open ಅಂತ ಐತಾ? Kept open. ಇದು kept open ಅಂತಾರ ಇದ್ರಲ್ಲಿ IFR-CD allow ಆಗ್ಬೇಕು.
CD.
IFR-CD has to be my lord considered because it is a below 60 days my lord.
Delay may be condoned.
Then 60 days my
so
lord.
there are two types.
ಹೌದು.
Also
This is pertaining to less than 60 days.
60.
This order pertains to less than 60 days.
Less than.
Less than 60 days kodri.
Less than ಕೊಡಿಯಾ?
Total
76 days.
Total 76 days.
Yes, ma'am.
That's it.
60 plus 60. 120 days total. 76 days. Original 40 days. Same.
60 by 60, my lord. Office is taking, my lord, 60 days will be already, they will detect it. Thereafter, my lord, they will show only 45, this is up to 60 days, they will show.
45 days.
This is 45, not.
45 days delay may be condoned, Lordship. Delay may be condoned. More than 60 days, they delay.
ಬೇರೆ ಆರ್ಡರ್ ಅದು we have past orders ಅದನ್ನ ಕೊಡ್ರಿ.
Kindly
Or
pass on, Lordship.
if you give the MFA number, similar orders ಅಂತ ಹೇಳ್ತೀವಿ ನಾವು.
Please, please.
ಆಮೇಲೆ ಕೊಡ್ತೀರಾ ಅಥವಾ ವಿಲ್ ಹ್ಯಾವ್ ಇಟ್ ಆನ್ ಮಂಡೇ?
ಆಮೇಲೆ ಕೊಡ್ತೀನಿ ಸರ್.
ಕೊಡ್ತೀರಾ?
ಕೊಡ್ತೀನಿ ಸರ್. ಕೊಡ್ತೀನಿ.
ಅವ್ರು ಕೊಡ್ತಾರೆ ಕಾಪಿ ಅಥವಾ MF ಕಾಪಿ ಕೊಡ್ತಾರೆ ಸೇಮ್ ಆರ್ಡರ್. ಇದು ಬೇಡ, ಇದು ಅವ್ರಿಗೆ ವಾಪಸ್ ಕೊಟ್ಟು.
ಅದು ನೆಕ್ಸ್ಟ್ ಕೇಸಿಗೆ ಬರುತ್ತೆ. ನೆಕ್ಸ್ಟ್ 24.
ನೆಕ್ಸ್ಟ್ ಕೇಸ್ ಇದಾಗತ್ತಾ?
ಬರುತ್ತೆ ಸೇಮ್.
24. Well, in this case, I undertake to file Wakala on behalf of claimant.
Learned Counsel Shri
Sangan Baswa B.
Sangan Baswa B. Patil undertakes to appear for
Claimant.
the respondent claimant.
82 days, my lord, delay may be kept open, my lord.
ಇದಲ್ಲ ರೀ.
My lord, another.
ತಗೊಳ್ಳಿ. So this is beyond 120 days, huh?
Yes, ma'am. Yes.
So similar order.
Yes, ma'am.
Previous matter ಅಲ್ಲಿ
Below one.
ಅದು that is below 120 days. ಅದು.
20 days. ಹೌದು.
Huh?
Below
Previous
120 days.
matter.
Condom ಮಾಡಬಹುದು.
ಆಯ್ತು, ಅವರು ಇನ್ನೊಂದು ಕೊಡ್ತಾರೆ ಇದ್ರ ಈ ಸೀರಿಯಲ್ ನಂಬರ್ 24 ಅಲ್ಲಿ ಸೇಮ್ ಆಸ್ MFA 202378 of 2024. ಕಾಪಿ ಇದೆ ಇಲ್ಲಿ.
24, 25, 27, 28, 29.
25 less than 120 days.
Yes, ma'am.
Same.
Not less than, but here, that's why I made the submission, my lord.
More than 120 days.
ಹೌದು.
25 ಅಲ್ಲಿ say more than 120 days. But this is SS Mamdapur.
Yes, ma'am.
ಹೌದು.
ನೀವಾ? This is
Kept open ಅಂತ IFCD kept open ಅಂತ.
same as serial number 24. ಆಮೇಲೆ 27
ಇದು kept open ಅಂತ.
same as serial number 24.
28 also.
28, I will undertake to file wakalat in respect of the respondents, claimants.
ಇದು ಅಷ್ಟೇ, same as serial number 24. Learned Counsel Shri
Harshvardhan R. Mali Patil,
Harshavardhan R. Mari Patil undertakes to appear for the respondent,
respondent.
claimant.
Claim.
ಆಮೇಲೆ same order.
29 and 31.
29 malord Sangan Baso people undertaken.
29,
Sangan Baso people.
Sangana Basava B. Patil.
Kept open
Huh?
the bill.
Same as serial number 24.
Yes, sir.
ಆಮೇಲೆ
31.
31.
31 I will undertake.
ಅದು
to
ಅಷ್ಟೇ
occur.
ಸೇಮ್ ಆಸ್ ಸೀರಿಯಲ್ ನಂಬರ್ 24.
Harshvardhan R.
ಹರ್ಷವರ್ಧನ್ ಮಾಲಿಪಾಟ್. Yes.
Please.
Seal number 27,
26.
26, Sharda Patil Kulgeri.
There is a delay of 144 days in filing the appeal.
ಕೊಡಿ. Learned government advocate takes notice for respond number 1. Respond number 2.
Learned single judge is only directed to consider the representation, my lord.
To notice to respond number 1. Full stop. The appellant is also permitted to serve copy of the appeal memo on Learned Counsel Shri Mahesh Patil, who appeared for respond number 1 before the learned single judge.
He is appearing, my lord. This is matter is, my lord, learned single judge. Kindly see the order of the learned single judge. Para 2, my lord. Is only direction to consider the representation in accordance with law.
Consider
Why have you filed this appeal?
File order. As per this application wants to appoint on compassionate grounds. So it was not considered because in the service records.
ಹೌದಮ್ಮ.
only it is-
You assign reasons and reject the representation. Why have you filed the appeal?
It came before the single bench filed the writ petition. Again, I was directed to consider.
But ಅದನ್ನೆಲ್ಲ ಏನ್ ಹೇಳಿಲ್ವಲ್ಲ ಇಲ್ಲಿ. Nothing has been discussed.
No, man.
In the order of the learned single judge, nothing of that sort has been discussed. So therefore, you give one more endorsement saying we have already considered your representation, we have passed an order dated so and so, the same will hold good ಅಂತ ಒಂದು ಕೊಟ್ಬಿಡಿ. ಅದಕ್ಕೆ ಅಪೀಲ್ ಯಾಕೆ ಹಾಕಿದ್ರೆ? ಏನಾದ್ರೂ ಡಿಸ್ಕಸ್ ಮಾಡಿ ನಿಮ್ಮ ಪ್ರೀವಿಯಸ್ ಆರ್ಡರ್ ನ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಇಲ್ಲ ದಟ್ ಇಸ್ ನಾಟ್ ಪ್ರಾಪರ್, ಯು ರೀಕನ್ಸಿಡರ್ ಅಂತ ಹೇಳಿದ್ರೆ ದೇರ್ ಇಸ್ ಸಮಥಿಂಗ್. ಏನು ಇಲ್ವಲ್ಲ ಇದರಲ್ಲಿ.
Because I filed appeal because the service record age was meant. He's not eligible, man. He's not eligible for appointment. That's why we did not consider it.
You are appearing for the first respondent.
House.
Huh?
House.
ಏನ್ ಹೇಳಿದಮ್ಮ? ಬೇಡ, ಇಶ್ಯೂ ನೋಟಿಸ್ ತೆಗೆದಾಕ್ಬಿಡಿ. Learned Counsel Shri Mahesh Patil is before this court
Tulsiram.
seeking leave to appear for respond number 1, who was the writ petitioner, original writ petitioner. Full stop. Next para. Learned Counsel for respond number 1, writ petitioner submits that the writ petitioner had approached this court seeking a direction to the appellant herein for chief officer of the municipal council, Wadi Junction, to consider his representation dated 11/10/2022 at annexure D, seeking appointment under compassionate grounds. Full stop. The writ petition has been disposed of with a direction to the appellant herein to consider the representation within an outer limit of 8 weeks from the date of receipt of a copy of the order. Stop. Learned Counsel would therefore submit that the order passed by the learned single judge is an innocuous order and it is not understandable as to why the writ appeal has been filed. Full stop. Next para. Learned counsel for the appellant submits that the application given by the petitioner seeking appointment on compassionate grounds was considered and rejected. Yavaga?
23-1. 23-1-2023. It was rejected.
On 23-1-2023. And therefore, the appellant cannot reconsider and pass orders once again. Full stop. Next para. Having heard the learned counsel for the appellant, the learned counsel for respond number 1, writ petitioner, and on perusing the petition papers, appeal memo, we are of the considered opinion that the appellant was only required to consider the representation dated 11/10/2022 and pass orders within an outer limit of 8 weeks. Full stop. Even if the application given by the petitioner seeking appointment on compassionate grounds were rejected by issuance of an endorsement on 23/1/2023, the same information would have been given to the first respondent, which would satisfy and comply with the directions issued by the learned single judge. We'll stop. We do not see any reason why the appeal should have been filed by the appellant here. Full stop. Next para. With these observations, the writ appeal stands disposed of, permitting the appellant to issue an endorsement to the first respondent, stating that the application and the representation given by the first respondent herein has already been considered and disposed of in terms of endorsement dated 23/1/2023. Full stop. A copy of the endorsement dated 23/1/2023 may also be enclosed along with the subsequent endorsement ordered accordingly. Starting a delay condoned.
Seal number 30-30, Bapugod Siddhappa.
For the appellant modes. The claimant's appeal for seeking enhancement mode. The notice to the respondent number 1 may be dispensed modes. The respondent number 2 is the branch manager, Reliance General Insurance Company. Reliance General Insurance Company.
Learned counsel, Srimati Preeti Patil Melkundi is requested to take for respond number 2. Stop. Learned counsel for the appellant is directed to serve copy of the appeal memo along with annexures on the learned counsel for respond number 2. Full stop. Next para. Learned counsel for the appellant has also filed a memo seeking dispensation of notice to respond number 1 on the ground that respondent number 1 is the owner of the vehicle and the liability has been fastened on respondent number 2 insurance company. Stop. At the risk of the appellant, notice to respondent number 1 is dispensed.
Delay may be refer to local, delay may be condoned. Delay of 101 days is there. Refer to local. The matter is settled to minutes of the amicably pre-conciliation.
Matter stands referred to The Lokadal.
Delay is there, Mursi.
Huh?
Delay is there, 101 days.
How many days?
101 days.
101. 101.
Yes.
ಪರವಾಗಿಲ್ಲ 101. Huh? 3 months ಏನಿದೆ? ಅದಕ್ಕೆ ಮುಂಚೆ refer to local ಅದಾಲತ್ ಒಂದು ಮುಂಚೆ since there is a delay of 101 days in filing the appeal and we are satisfied with the explanation offered, delay is condoned. IA number 1 of 2024 is accordingly disposed of. Adadmele refer the matter to local.
Number 32, preliminary matters. PG CH-2.
I am from the complainant. Not sir. These complainants are not sir, are the weaker sections and they are residing in Indira Nagar slum area at Mudebial. Not sir, there is a threat for demolition of the houses. Not therefore the petitioners, all the complainants have filed a writ petition before this honorable court. And this honorable court granted interim order. Your lordship kindly see not relevant page number 15. Pending disposal of the above writ petition, the honorable court be pleased to issue interim order of
So
direction.
you are on the interim order.
Yes, miss.
The matter still pending consideration
Yes,
before
yes,
the learned single
Yes,
judge.
yes. Miss. No, sir, after that, this interim
ಯಾಕೆ
order.
ಅವ್ರ ಗಮನಕ್ಕೆ ತರಕಾಗ್ಲಿಲ್ವಾ ನೀವು?
ಇಲ್ಲ, issue, ಅಂದ್ರೆ contempt, they have demolished the house. Miss. I have produced the copy of.
Do you not bring it to the notice of the learned single judge?
It is amount to contempt, not therefore I have filed a contempt.
So the learned single judge has no power.
Sir.
Huh? He has no power to take action if there is violation of his orders.
Then I have not filed in.
ಇದೆಯಾ ಇಲ್ರಿ?
Illa, that
Power ilva?
power may be immense, but that contempt can be filed only before the, my respect to submit, that
That
may
is why
be.
we are asking you.
Yes, yes, there no power.
Why have you not brought it to the notice of the learned single judge?
Not sir, single judge also can initiate a contempt proceedings and refer the matter put to this honorable court.
Yes.
Therefore, I am directly filed this contempt petition. It can not. Your lordship kindly see the paper publication I have produced. After receipt, they have received the copy of order on 5/10/2024. And they have demolished the houses, all the poor persons, and they say, said by using bulldozer. Produce the paper publication. Your lordship kindly see the paper publications. That was in the presence of the Adhyaksha. Even though that was, they have approached the Tahsildar and give the protection. And plus, these all the persons have given issued a Hakupatra and registered documents.
Issue notice.
Emergent notice.
And to learned government advocate takes notice for respondent number 3. Learned counsel for the complainant is directed to serve copy of the contempt petition along with annexures on the learned government advocate.
Emergent notice.
Yes. Emergent notice.
Please.
Huh?
10 days.
Returnable by
Please.
11th of November.
Seal number 33, GG CH-2.
It is also same. Two
Same.
batch. Yes.
32, 33,
33.
ಎರಡೇ.
Yeah.
Yes.
Seal number 34,
First, the petitioner filed application before the Honorable Karnataka State Administrative Tribunal for passing up article of charges and alternative prayer writ of mandamus to give the promotion. Thus, the promotion is held up due to inquiry. That the departmental inquiry is initiated against the petitioner. Due to that inquiry, the petitioner promotion was held up. That inquiry article of charges as questioned before the Honorable Tribunal. The Honorable Tribunal allowed my application in so far as that and passed the entire article of charges because of the but so far as alternative prayer that was dismissed. Mandamus. Mandamus. I have sought for alternative prayer mandamus to issue direction direct because on the pendency of the inquiry, my promotion was held up. Therefore, I sought for alternative prayer notes. So page number 28, para 10 minutes. In view of the discussion made above, the application partly allowed, the impugned order so and so passed by the first respondent imposing penalty is quashed. The withheld pension is in so far as
That
alternative.
prayer is rejected.
Yes, no. So far as alternative prayer merits that was rejected. So that prayer merits have come. This petition failed.
Learned government advocate
All,
takes notice for all the respondents.
please.
Learned counsel for petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on the learned government advocate.
Please.
Yes.
It may be taken on next week, not silent. It may be can be disposed of.
No. Let us see. Yes.
CL number 35, Prakash Jadhav.
Hearing behalf of the petitioner in this case, my lord, the petitioner challenging the 14A KCSR issued by the government against to the petitioner. So, in Lokayukta case, my lord, already bar created section 8. Section 8 of the Karnataka Lokayukta Act 1984, wherein 1B and 1D created the bar. Already the departmental inquiry held against the petitioner, it was a concluded wherein the petitioner was exonerated by the consent authority. Subsequently, the complainant approached to this honorable court, and this honorable court is directed that approach to the once against the competent authority. He was once again is a approach to the competent authority is exonerated to the petitioner. Thereafter that he was filed the complaint before to the Lokayukta. So that complaint is not maintainable because section 8 of the Karnataka Lokayukta Act created the bar.
You have filed a writ petition directly before this court.
Yes, my lord.
Why?
The seeking the
before the division bench.
the Lokayukta all cases come to the division bench.
Howda? Huh? Huh? Oh.
Lokayukta and KT matter come to the division bench. my lord.
Circular idea tara. Circular idea.
So please kindly see page number 39 of the my petition, my lord. Para 2, kindly permit to me read this contention. ತನಿಖೆ ಅವಧಿಯಲ್ಲಿ ಲಗತ್ತಿಸಿರುವ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದೆ.
We are trying to find out how this writ petition is maintainable.
Pardon. Please.
This is not arising from orders of the tribunal, isn't it?
Yes, my lord.
You are a government, sir. No. Gram Panchayat clerk.
Clerk. I am not a government servant, my lord.
How this matter has come up before the division bench is what we
Because
are
my lord,
asking you.
the retired judges of the Honorable Lokayukta, therefore the matter is a place before to the division bench.
They have not passed orders.
Already there is a circular retired High Court judge, so that,
Annexure H.
yes, my lord. Annexure J and H. As per J, they issued the 14A.
J is another order passed by this court. G and H.
Yes, my lord. J, I am seeking the quashing the G. H is a charge of memo issued by the Lokayukta. Earlier, I was approached to the challenging to Article 12.3. The same division.
G is an order passed by the government.
Yes, my lord. The 14A issued against to the petitioner. The recommendation to the Lokayukta conduct to the departmental inquiry against the petitioner.
H is only a charge memo.
Charge memo, my lord.
Then,
so G is a not maintainable, firstly. G is a not maintainable. So it is a created the bar under the Lokaयुक्त Act 1984, Section 8.
We are asking you why you have come before the division bench.
My lord, I am seeking the question to the G. G is issued by the government.
Government.
Yes, my lord.
Then why are you not going before the learned single judge?
No, my lord, this matter is a come to before to
How?
division bench.
That
The
is what we are asking you.
circular is issued by the,
Let us see, sir.
kindly pass on, my lord, I will. Already the same.
I don't know why office does not look into all these things. There is no order passed by the Upalokayukta or the Lokayukta.
Yes, my lord.
Then
Already also I am.
we are told if an order is passed by the Upalokayukta or the Lokayukta, then the matter may come up before the division bench. No orders are passed.
Yes, sir.
Then this matter should go before the learned single judge. Registrar.
My lord, kindly annexure G also.
The reason why it is said the when if an order passed by the Lokayukta or the Upalokayukta may be brought before the division bench is because they are retired judges.
Yes, yes.
No such order is passed by the Upalokayukta or the Lokayukta here. And the circular says so. If that is so, this should go before the learned single judge.
Yes, you are right, my
Not
lord. But my lord, kindly see the
have
J.
it on Monday.
J. Already we approached to this honorable court. The division bench also is decided the case. ಇದರಲ್ಲಿನೇ ಇದೇ issue ಒಳಗಡೆ
ಅಲ್ಲೂ ಈ objection raise ಮಾಡಿಲ್ಲ.
ಹೌದು ಆಗ್ಲಿಲ್ಲ ಸರ್. ಅವರು
we are not going to leave it like that. If some mistake has been committed earlier, we are not going to say all right, we will do the same mistake. No, we are not going to do that. If that objection was not raised and it is not answered, you are required to answer it now.
Yes, my lord, kindly Monday take the matter Monday. I will also just search the circular and the.
We see that the petitioner has filed this writ petition challenging a government order
Dated
13/2/2023 and a charge memo
dated 31/3/2023.
dated 31/3/2023 issued by the additional registrar bracketly enquiries of the Karnataka Lokayukta. Full stop. Normally, such matters should go before the learned single judge. Full stop. Next para, learned counsel for the petitioner is required to answer as to how this matter is placed before the division bench. Full stop. Release this matter on 28th of October. New circle. Yes.
Millard, kindly 29, Millard, 28 somewhere I am.
29.
Yes, ma'am.
All right.
Much only.
Admission matters, CL number 46, Venkatesh Mallabadi.
Matter is called out. There is no representation for the appellant. Full stop. Even on the previous occasion, there was no representation for the appellant. Full stop. Next para. Release this matter on 5th of November 2024. Full stop. If there is no representation for the appellant on the next date of hearing, the appeal will be dismissed for non-prosecution.
CL number 37, government advocate, additional.
Yes, my lord, I am for respondent and I have filed cross appeal also. On 3/9, my lords, I have filed the comparative chart as per the instructions of this honorable court, my lord. Last may kindly see the order dated 3/9/2024.
They are making submission, my lord, other LIC cases, my lord, not fit ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಇದು ಕೂಡ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ, ಇದನ್ನು ಡಿಸ್ಮಿಸ್ ಮಾಡಿ ಅಂತ their contention, my lord.
I have
That
filed the
was placed
comparative
before the
chart.
committee,
Chart
my
has
lord.
been filed.
Committee has taken the decision, my lord, to file the appeal in that cases also, who has not made the fit.
How can you say, no, in a similar matter, they have said not a fit case. In this case, they have said,
Not similar matter, my lord. Same notification, same village, same
ಇರ್ಬೋದು.
purpose, common award,
ಇರ್ಬೋದು.
common award.
You will not, it is not as a matter of right, you can say, no, they cannot file an appeal in my case. ಹಂಗೆಲ್ಲಕ್ ಬರೋದಿಲ್ಲ.
ಅಲ್ಲ pick and choice ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಅವ್ರಿಗೆ. Pick and choice
No.
ಮಾಡ್ತಿದ್ರು.
That cannot be considered. We cannot say, we cannot ask the government, why have you filed an appeal in this case, in others you have not filed ಅಂತ.
Same
ಹಂಗೆಲ್ಲ ಕೇಳಕ್ ಬರಲ್ಲ.
ಒಂದ್ ಕಾಮನ್ ಅವಾರ್ಡ್ ನಲ್ಲಿ ಸ್ಯಾಟಿಸ್ಫೈ ಮಾಡ್ತಾರೆ.
We are not going to ask the government like that. We cannot ask also.
Last occasion also they made a submission that they are going to withdraw those appeals, madam.
No.
ಅಲ್ಲ,
ಅವ್ರು
ಮಾಡ್ತೀವಿ,
ಹೇಳ್ತಾರೆ,
ಮಾಡ್ಲಿ.
that is recorded.
No. We,
39 ಗೆ ಹೇಳಿದಾರೆ, ರೆಕಾರ್ಡ್ ಆಗಿದೆ ಅಂತ ತಾವ್ ಒಂದ್ಸಲ ನೋಡಿದ್ರೆ 39 ಆರ್ಡರ್
if it is my lord directed, then.
39 ದಲ್ಲಿ ಹೇಳಿದಾರೆ ಅವ್ರು 39 it is
ಏನೂ ಇಲ್ಲ.
Geo pass
At
ಆದ್ರೆ
request,
ಮಾಡ್ತೀವಿ.
release this matter on so and so.
ಅದಲ್ಲ 3 ಆರ್ಡರ್ ಎಂಟೈರ್ ಆರ್ಡರ್ ಇದೆ ಸರ್ 39 ಗಿದೆ ಸರ್
39
ಎಸ್ ಮೇಲೆ ಆರ್ಡರ್ ಡೇಟ್ 39
ಇದೆಯಲ್ಲ, I am seeing order 39.
MFA ನಂಬರ್ 201002
ಕೊಡ್ರಿ, ಏನ್ ನೋಡೋಣ. 201
1002
ಇದಲ್ಲ ಇದು.
First matter.
ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್ ಇದೆ ನೋಡ್ರಿ.
My lords, may I read it that order?
ಓದಿ.
The learned counsel for the claimants has provided a comparative chart of the lands which are subject matter of the appeals and has filed a table and submit that insofar as survey number 18/3D, 12/3, 12/2, 30/2 of Kagod village, the order of the reference goes part in LSA number 1 of 19, 2 of 19, 14 of 19, 15 of 19, and has been accepted and awards are satisfied. It is further submitted that in all the lands which are subject matter of the present proceedings, common award was passed by the special land acquisition officer, and the rate fixed for dry land and irrigated land by special land acquisition officer was the same insofar as all the sets of lands. It is further submitted that as the lands which are subject matter of the proceedings in the present set of appeals are of the same Kagod village, they are open to the accepting the compensation as awarded by the reference court if the state were to withdraw its appeal. It is further submitted that they would not press their cross objection as well. However, it is submitted that this submission is subject to the state accepting the awards of the reference court and were to withdraw the appeals. For the say of the state list the matters on 23rd so and so.
Yes.
Yes, for that is the reason, my lord, we place all the matters before the committee, my lord. Committee is directed to us to file the appeal in the not fit case also. That is the decision is taken, my lord.
ಅದ್ರಲ್ಲೂ ಮಾಡ್ತಾರೆ ಅಂತ.
ಹೌದು.
ಅಮೌಂಟ್ ಸ್ಯಾಟಿಸ್ಫೈ ಆಗಿ ಇವಾಗ ಮಾಡ್ತಾರೆ.
ಹೌದು, ಮಾಡ್ತಾರೆ.
Satisfy ಆಗೋಗಿದೆಯಾ?
ಆಗೋಗಿದೆ. The amount is already dispersed.
My lord, even then, my lord, we have right to file the appeal. Why wrongly, my lord, someone wrong decision was taken. Wrong
Wrongly ಹೆಂಗಾಗುತ್ತೆ?
Not fit ಅಂತಂದ್ಮೇಲೆ that is what is left out, my lord, only 3 cases. Now, my lord, ascertain that will be affect to all the cases. But that is the reason, my lord, the director.
What will you do with the matters where you have dispersed the compensation?
That was, my lord, deposited before the, my lord.
Disperse ಮಾಡಿದ್ರೆ
Executing
C
court.
form also.
Executing court, my lord, there was a warrant. For that is the reason they deposited the entire amount. Now, my lord, that is awake and passed the necessary order by the committee. No, you also filed the appeal in those cases also.
How will you file if your compensation has been dispersed?
If we right of the appeal will be there, my lord. If it is, my lord, if it is reduced, my lord, we are right to collect.
Where is all that information that you are saying now?
Pardon, my lord.
Where do you get all this information from?
That is, my lord, the committee has the instructed
Please
to me.
bring to the
I will-
court whatever information you have received. We will see.
I will produce.
Barkali. On 3/9/2024, in MFA number 201002 of 2022 and connected matters, this court had recorded the submissions made on behalf of the claimants. That
He made the submission to withdraw the cross appeals, my lord.
Yes.
That is one.
ಅಲ್ಲ, that.
We not made
That
the,
is-
we not made the,
ಇಲ್ಲ, court
we
has
not
put a
made the
question.
objection, submission, my lord.
What happened?
Withdrawing these appeals, my lord. We are not made.
What happened?
Hangilla. It is also made clear that it is only for exploring the
Yes.
possibility of settlement.
Court put a question
But,
there. Yes, ma'am.
There is substance in the submission because if in the similar circumstances in the
Same.
neighboring village, you have accepted the verdict and you have dispersed the compensation.
Yes, ma'am.
How is it that you file appeal only in these matters?
Yes, ma'am. That's why, my lord. Oh, my lord, they taken the decision, my lord. Even
You
the,
are also required to answer.
that's why, I will answer.
How
That's
did you
why.
accept and pay the compensation in the other
Yes, ma'am.
matters, connected matters?
Yes, yes. I will answer.
But you have preferred appeal only in some of the other matters.
Yes, I will file the
That is why
affidavit
it was
of the,
recorded.
yes, ma'am. I will file the affidavit of the SLO, my lord, regarding that one also.
ಏನಂದ್ರೆ? That on the basis of the common award passed by the special land acquisition officer and the rate fixed for dry land and irrigated lands. The respondents have accepted the decision of the reference court in respect of adya pakkad village adu
The same village, not Pakka, same village, ma'am.
in respect of some other properties from the same village, that is Kagod village,
Please.
and compensation amount has been dispersed. Full stop. However, the state has chosen to file appeal only in few of the matters. Stop. Therefore, directions were given to the learned government advocate to secure instructions as to whether the state is willing to withdraw the appeal. Since the appellants claimants have also submitted that they are ready to withdraw the appeals if the state withdraws the appeal. Full stop. Next para. Learned government advocate submits that as per his instructions, the committee has taken a decision to prefer appeals.
Committee has orally directed the, my lord, SLO to prepare.
Full stop. Comma, full stop. Next para. Nevertheless, comma, having regard to the order dated 3/9/2024, comma, if any information is received by the government advocate, comma, the same is required to be placed before this court. Full stop. Release this matter on 11th of November.
Please.
22 ದಲ್ಲೇ ಡಿಸ್ಪರ್ಸ್ ಮಾಡಿದ್ದಾರೆ, ಅಮೌಂಟ್ ಸ್ಯಾಟಿಸ್ಫೈ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ನೀವು ತಗೊಬನ್ನಿ ಇನ್ಫಾರ್ಮೇಶನ್. ಲೆಟ್ ಅಸ್ ಸಿ.
ಅಲ್ಲಿ ನಾನು ಆಲ್ರೆಡಿ ಫರ್ನಿಸ್ ಅಲಾಂಗ್ ವಿತ್
ಹಾಕಿದೀರಾ?
ಹಾಕಿದ್ದೇನೆ ಸರ್.
ನೋಡ್ರಿ ಎಲ್ಲ ಇನ್ಫಾರ್ಮೇಶನ್ ಇದೆ ಅಂತ ಅಲ್ಲಿ ನೋಡಿ.
ಕೊಟ್ಟಿದ್ದೇನೆ ಅಲಾಂಗ್ ವಿತ್ ಮೆಮೋ ಅಂಡ್ ಅವಾರ್ಡ್, LA award and satisfied,
You cannot
where we are
pick and choose.
satisfied,
Please.
judgment and form, everything are furnished.
Seal number 38, Arun Kumar Amar Gundappa.
Please, may it please, my lords. My lords, appearing for the learned counsel.
Yes.
Appellants, my lords. My lords, the prayer appellant hearing is regarding the OTS scheme, my lord, that has not been properly applied. Is his case, my lords. Annexure A, page 46, my lord, is the OTS scheme. The total amount due was 97,84,000 odd. The OTS amount offered was 73 lakhs. In fact, my lord, this is exactly during that COVID period, October 20th is the OTS scheme, my lords. And unfortunately lost his Doddamma aunt, my lords, maternal aunt. He had to spend about 11 lakhs. The loan amount, my lord, is disbursed on his petrol bunk, which had to be closed because there was an acquisition proceedings, and continued to be so. My lord, this honorable court may directly beg to take my lord's order, my lord, earlier order, when my lord was heading the division bench on 20th 12 2023, my lords. It is the contention 20th December 2023, my lords. The contention of appellant that although there is delay of 2 months in paying the amount agreed in terms of the one-time settlement scheme, nevertheless, the amount has been paid. On the other hand, consider the respondent bank that the law is very clear that once the terms and conditions of one-time settlement are not complied, the payment cannot be taken as compliance. Indeed, the considered opinion of the court, the parties are required to amicably settle the matter. Respondent bank is required to put it to the appellant as to what is the additional amount that could be payable by the appellant. Then 2 weeks time was granted, my lords. Total OTS amount was 73,38,000. That entire amount has been paid, my lords.
We had indicated that since they have already paid the money, there was a delay of 2 months.
There was scheme was over. Thereafter, they have directed to give representation to subsequent. They have given representation to the bank. A committee was there in Reserve Bank high level to extend the time or give a further time to it. Because it is not a single person's. It will have floods will be open, my lord. If we open, that concession was given.
See, as per the OTS scheme,
Yes.
a particular figure was made known to the borrower.
Yes,
And he was required to pay it within a particular day. Isn't it?
yes, ma'am.
He did not make the payment on that day.
Yes,
But he made the payment 2 months after that.
yes, ma'am.
So therefore, we had indicated to you in this order dated 20th of December 2023. In the considered opinion of this court, the parties are required to amicably settle the matter. The respondent bank is required to put it to the appellant as to what is the additional amount that could be payable by the appellant.
Yes, he has given a representation in response to that.
Yes.
Subsequent order of this court is also there. He cannot enter into a contract. It is against Appellate court judgment. You can give only.
No, please understand what is the amount that was agreed to be paid and
my lord,
what was the amount agreed?
Annexure A offer is 73,38,388, my lord.
This is as per your memo of calculation dated 7/2/2024.
Please, that has been deposited, my lord. One contention now they say court amount has not come to us. Court amount has not still come to us is one contention they are now saying, my lords. Amount which is in deposit.
What amount?
Court al deposit madidvi, matte because there was a direction by this honorable single judge and also by this honorable court, my lord, certain amount to be deposited. Adu amount nam bandilla anta iga there is some contention, my lords.
This amount was directed to be deposited in the court, is it?
Some amount, my lords. Total 25 lakhs is before the honorable court, my lords. 20 totally because before the learned single judge 15 lakhs. Before this honorable court, my lord, 10 lakhs. Totally 25 lakhs was deposited before this honorable court, my lords. That amount they say is not come to us. We don't want to take into account. I don't want to stand down any technicalities, my lord, that the amount go to them, my lord, if it has already not gone to them. Amount which is in deposit. But they are required to take account every amount, my lords. Now the entire amount is now paid. Now, my lord, our submission is they should indicate what amount is now payable by us, my lords. The State Bank of India, my lords, our situation was that he lost his Doddamma during that COVID period. He has spent 11 lakhs, which is the bills are also produced. In our society, my lord, he is required to take care of his Amma and Doddamma, everybody, my lords.
The OTS amount
please.
Was 73 lakhs 38,388.
Please, my lords.
Memo of calculation hakidar nodi.
Houdu.
They have paid 72 lakhs 286.
Please, my lord.
That was deposited here.
You could have made a submission before the court, sir. Why should we keep it in the custody of the court?
So they
could have directed them to deposit that amount with you.
Even my lord.
Submission madad bittu.
No, my lord. Even otherwise.
Both of you have committed this mistake.
I bow down, my lords. They have no.
You should have sought for a direction to deposit it with the bank. Would have permitted you.
I bow down, my lord. That's I do consider this, my lords. Your lordship has got made this one, both of us, my lords.
ಇವಾಗ ಎಷ್ಟಿದೆ? All this amount has been deposited before the court, is it?
ಅಲ್ಲಲ್ಲ 25 ಲಕ್ಷ ಮಾತ್ರ ಕೋರ್ಟ್ ಅಲ್ಲಿ, ಬೇರೆ ಎಲ್ಲ ಅವ್ರಿಗೆ ಕೊಟ್ಟಾಗಿದೆ.
ಎಷ್ಟು ಅಮೌಂಟ್?
Last two items, my lords, in the memo, 15 lakhs, second item, my lords.
15 lakhs ಮತ್ತೆ 10 lakhs.
10 lakhs, my lords.
This 25 lakhs you have deposited before the court.
Please, in fact, my lord, subsequently.
You will direct.
That direction
was also
by the
issued.
court also. Representation could until this court is earlier order.
May I take the
Order
honorable
this
court, my lord?
earlier,
Please.
the earlier
May I take the honorable
subsequent
court to-
order, my lord, passed by this court.
And this is 6/8/2024.
Directed to give representation.
6/8/2024, my lord.
Direction ಅದು?
6/8/2024 again.
There is a direction by this.
Please, I will read. 6/8/2024, appellants permit to approach the concerned respondent bank again. If there is chance of settlement, matter may be referred to Lok Adalat. While making such a reference, it would be clarified. 6/8 is important order of this one court. It will be clarified that the settlement arrived would not act as a precedent in other matters. This was their contention. This will become precedent, as my learned friend is submitting now.
Alri, why did you not seek directions to get it released and deposit with the bank?
ಮತ್ತೆ ಆಗಿದೆ ಸ್ವಾಮಿ, 14/8 ಆಗಿದೆ.
It is still lying with the
ಈ ಡೈರೆಕ್ಷನ್ ಆಗಿದೆ
ಆಗಿದೆ, 14/8 ಆಗಿದೆ, ಮತ್ತೆ 14/8 ಆಗಿದೆ. 14/8
last date of hearing, I think they have directed.
Submit has been deposited in the writ proceedings so and so as well as the present appeal proceedings. About the amount stated to have been deposited after.
And also they have directed to.
That's the aspect, whether it's transferred or not, my lords.
ಮೊನ್ನೆ circular
Is to be transferred. On 6/8, this honorable court said, let it not be treated as precedent, but go on with the mediation if possible, my lords. Then next date, 14/8, it was ordered.
14/8/2024.
Mediation ಹೋಗಿ ಅಂದ್ರು.
That amount stated to have been deposited after verification is to be transferred by the registry to the respondent bank.
Please.
Upon bank furnishing necessary details.
Yes.
ಆಗಿದೆಯಾ?
ಅಲ್ಲ ಅದು ಅಲ್ಲಿ ಕಳಿಸಿದಾರ. We are not accounted.
ಬಂದಿದೆಯಾ?
ಅಲ್ಲ ಬ್ಯಾಂಕ್
No, my lord.
details ಅವರು ಬ್ಯಾಂಕ್ ಅವರು ಕೊಟ್ಟವರಿಲ್ಲ.
That subsequently representation is also given.
ಆಯ್ತ್ರಿ, ಅದನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಿ. Please tell us what is the amount payable.
ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ, I think they have given reply to them, my lord. They have replied was.
ನಾವು ರಿಕ್ವೆಸ್ಟ್ ಕೊಟ್ಟಿದ್ವಿ, ಬಾಲಶಾಲೆ
Reply was given to them on the representation given by the banker, and the committee was inspected it. Feasibility has seen, unit has been verified. And if everything is order in that view of the matter, in the light of the guidelines of the RBI, there's detailed reply was given, what is the amount has been submitted to them as per the direction of this court.
To submit everything may kindly be ordered to be placed on record, because bank has to, SBI has to.
That reply. That all reply and
not like a financier, my lord. Not like other financier, my lords, because Article 15 mandates that is required to state entity, my lords, fairly and submit.
And not only one account, my lord, this is a large account. It is
no, that's why this on court.
Therefore, a committee has.
No, on 6/8.
Committee is consulted by Reserve Bank of India. They visited it. Unit, feasibility, everything they have got, they have rejected it, ma'am.
Let them place everything on record. 6/8 order is very clear, my lord. Let it not be treated as a precedent. This will take care of the interest of the bank also. My lord, I only pray, my lord, so this honorable court's previous orders, all of them echo that is a matter fit for some amicable settlement. It is not as if that we are running away. We are paying, my lord.
Detail or reply ಕೊಟ್ಟಿದ್ದಾರಾ?
See, that amount has been transferred to you on 31/8/2024.
Recent.
What is the amount that you have received? If it was kept in fixed deposit, and if it is given along with interest, you would like to know what is the amount that is deposited to you.
I'll get it, my lord. What is the total amount of it is kept in the center only.
ನೀವು ಅಡ್ವೊಕೇಟ್ ಮಾಡಿರೋ ತಪ್ಪಿಗೆ ಈಗ the party is suffering.
In fact,
you should have said, ask them to deposit with the bank. Why should it be deposited in the court?
So they have filed a writ petition. They have taken orders. I subsequently appeared. I don't know. Then we argued the matter. A writ petition maintainable until main argument ಮಾಡಿದ್ರು.
ಅಲ್ರಿ, ಇವಾಗ substantial amount, even in terms of the OTS, they have already deposited.
Even then, my lord,
Sir, court is empowered to issue directions to the bank, taking note of these events.
Supreme Court has
ಏನಾಗಿದೆ
said,
ತಪ್ಪು ಅಂತಂದ್ರೆ, instead of depositing in the bank, it was directed to be deposited in the court.
not even that, my
So
lord.
we would like to know what is the amount that you have received on 31/8/2024.
Yes, we will furnish, my lord.
You
Not
please
even,
tell us, we'll see.
not even that, my lord. The ODS extension is also. Conduct of the borrower is something is different, my lord. Therefore, the apex court repeatedly said the writ petitions of such writ petitions is not maintained before the High Court, when an alternate remedy is available for them.
During the course of these proceedings, in terms of the directions issued by this court, the appellant deposited rupees 15 lakhs on 4/4/2022 and rupees 10 lakhs on 1/3/2023 before the registry of this court. Full stop. By order dated 14/8/2024, it was directed that the registry shall transfer the said amount to the respondent bank. Full stop. Accordingly, on 31/8/2024, the respondent bank has received the said amount from the registry. Full stop. But it is not clear as to whether the said amount was transferred along with the interest accrued thereon. Full stop. We therefore call upon the respondent bank to furnish information as to the amount received from the registry of this court in terms of the refund voucher dated 31/8/2024. Full stop. Next para. Release this matter on 30th ಆಗ್ಬೋದಾ? 30th ಅಲ್ಲಿ information ಸಿಗುತ್ತಲ್ಲ? 30th of October 2024.
Yes, most of it.
Yes.
39, Shivashankar H. Manur.
Lord, the petitioner challenging the order of the learned single judge. In this case, Lord, the petitioner applied for the post of Anganwadi Karyakarta.
Condonation of delay of 29 days.
But I'm seeking also interim order of stay. And also I'm for interim order of stay. Since the matter is
Your
urgent.
petition was dismissed.
Yes, the order is error, my lord. I can show the order, how it is error, my lord. And the matter seems urgent, my lord.
ಅವ್ರಿಗಾಗಲೇ appointment ಆಗಿ she is working there.
What happened, my
Then
lord?
what
in
can
this-
be done?
My point is, my lord, here. The
Learned
post,
government advocate
my lord.
takes notice for respondents number 1 to 3. Issue notice to respond number 4. Stop. The appellant is also permitted to serve copy of the appeal memo along with annexures on learned counsel Srimati Ratna N. Shivayogi Mat, who appeared for respond number 3 before the learned single judge. Please give a copy.
Yes. Yeah, my lord, my request regarding
List this matter
my lord,
on 30th of
my lord,
October.
my prayer for urgent, my lord. What happened? Particular post is given to respondent number 4, Anganwadi Utnal place, my lord. The C was not the AC candidate, my lord. Though C was not.
On merits, how can you make submissions on the merits of the
I'm
matter
not
now?
going against.
Matter has been dismissed. She has been working now.
What? I'm not
What interim
disturbing,
relief can be
I'm not
given now?
disturbing respondent number 4. What happened?
Ah.
The post is reserved for SC. GM.
ಮತ್ತೆ ಹಂಗೆ ಹೇಳ್ತಿರಲ್ರಿ.
One second, what urgency is
What
required?
relief can be given now? You please tell that.
Relief, my lord, the same post again they made vacant and they called for the post, my lord. That cannot be done. The post reserved for SC, GM was appointed instead of me. And thereafter they come to the knowledge that it was, she is a GM candidate. She was transferred to other place and same post vacated. And now they called for the post and the applications are called for the same post. So my prayer is that post cannot be filled till disposal of this case, my lord. Same place became vacant, my lord, because GM candidate was appointed. They came to know after the passing of the order. Now they are realizing that their error, my lord, they transferred to the GM post and that ST post became vacant and they called for the notification pulling the SC post, my lord. So now
They have issued a notification now.
yes, my lord, for the same post for the SC candidate. They made a error, my lord.
Where is the notification?
My lord, this is a fresh notification. Therefore, I moved the matter.
It's not here.
Not it's
On record.
my lord. Now they have called notice, my lord.
Kodi.
This is notification for the same post, my lord. So till disposal of this petition, my lord, in respect of Utnal post, my lord.
ಎಲ್ಲಿದೆ ರೀ?
Annection. ಅದರಲ್ಲಿ ಪ್ಲೀಸ್ ಒಂದೇ ಈಗ ಬಂದಿದೆ ನೋಡಿ ಕಾಪಿ ನನಗೆ ಪ್ಲೀಸ್.
It is only a general notification, that's all.
Same post was called, my lord, still number 8. This is the subject matter of the writ petition, writ appeal, my lord. So that cannot be fulfilled, my lord, till disposal of the petition. Serial number 8, my lord, in the annexure, Utnal village, my lord.
ಎಲ್ರಿ, how do you say it? This forms part of this notification?
Yes, ಅದರಲ್ಲಿ ಬರ್ತಿದ್ದಾರೆ, my lord. Annex.
ಅನುಸೂಚಿ 1 ಅಂತ ಎಲ್ರಿ ಇದೆ ಅಲ್ಲಿ?
ಇದೆ, my lord. ಪೋಸ್ಟ್ ಕರೆದಿದ್ದ ಬಗ್ಗೆ ಏನು
ನೋಟಿಫಿಕೇಶನ್ ಅಲ್ಲಿ ಎಲ್ಲಿದೆ ತೋರಿಸಿ.
ನೇಮಕಾತಿ ಜಿಲ್ಲಾಧಿಕಾರಿ ವಿಜಯಪುರ ಅವರ ಅನುಮೋದನೆ ಮೇರೆಗೆ ವಿಜಯಪುರ ಜಿಲ್ಲಾ ಚರ್ಚೆ ಹುದ್ದೆಗೆ ಸೆಟ್ ಅಸೆಸ್ಮೆಂಟ್. This is a complete notification, my lord. This is as per my request, they have given, my lord. It is my request, my lord. they have given this notification and this is an annexure of the notification.
Next para, particularly. Learned counsel for the appellant submits. That the respondent authorities have once again issued a notification dated 9/10/2024 whereby the post of Anganwadi worker at
Utnal village.
Utnal -925 of Vijayapura city for the reserved for the post reserved for the category of scheduled caste has been issued and published. Full stop. Learned counsel would therefore submit that it is very clear from the subsequent notification that the respondent authorities have realized that the fourth respondent who does not belong to scheduled caste category was appointed under the general category.
Yes.
And once again, the said post and thereafter she has been transferred to some other Anganwadi Kendra.
Yes.
And once again, the post has been advertised showing that it is reserved for scheduled caste category. Full stop. According to the learned counsel, it is very clear from the said aspects that the fourth respondent was not eligible for appointment as Anganwadi worker in the said Anganwadi Kendra because she did not belong to scheduled caste category, has however managed to secure the post and thereafter she is transferred to another Kendra. Stop. Next para. Learned government advocate is directed to secure instructions as to whether the submissions made by the learned counsel for the appellant is correct. Full stop. Information is required to be placed on record as to whether respondent number 4, who was appointed as Anganwadi worker at Utnal of Hitnarli village, has since been transferred to some other place. Full stop. Till the next date of hearing, no precipitative action shall be taken by the respondents for appointment in terms of the subsequent notification dated 9/10/2024. Yes. Release this matter. Huh?
Her side is made
30th.
submission that, my lord, they are already working, my lord. She is working, Allah.
Not working.
She is not.
Our fourth respondent is working.
Post respondent.
You have understood what is the submission.
Yes, yes.
The post was actually reserved for scheduled caste category.
Yes.
Fourth respondent was not of scheduled caste category, but she was appointed. Now they realized that that post was to be reserved for scheduled caste category, and to ensure that the posting is not set aside, they have transferred her to some other place, and once again advertised the same post for scheduled caste category.
That is
the allegation.
I will verify it.
Yes.
Full set copy is not given. Copy input order is
ಇದನ್ನು ಕಾಪಿ ಕೊಡ್ರಿ ಅವ್ರಿಗೆ.
I will give.
ಇದು ಕಾಪಿ ಕೊಡ ಕೇಳಿದಿನ. Learned counsel for the appellant is directed to serve copies of the appeal memo along with annexures on the learned government advocate as well as learned counsel for respondent number 4.
Three.
Three na?
Three.
Three na iವ್ರು?
ಅವ್ರಿಗೆ
No,
notice
three, my
ಹೋಗ್ಬೇಕು.
lord. Four is the party.
ಅವ್ರಿಗೆ notice ಹೋಗ್ಬೇಕು.
Four was the candidate. Four was the, respondent number four was the candidate. Three, madam, ಇದ್ದಾರೆ.
ಅವ್ರಿಗೆ
Three
notice
ಯಾರ್ರಿ?
ಹೋಗ್ಬೇಕು.
Three, madam.
Jilla Panchayat.
Jilla Panchayat.
ಜಿಲ್ಲಾ ಪಂಚಾಯತಾ? ಹಂಗಾದ್ರೆ who appeared for that candidate there?
Candidate, my lord.
ಯಾರು
notice-
ಅಪಿಯರ್ ಆಗ್ಲಿಲ್ವಾ?
Notice has to be issued.
ಅಲ್ಲಪ್ಪ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಮುಂದೆ who appeared? None appeared for the candidate? Respondent number 4?
ಇಲ್ಲ, none appears, my lord.
Huh?
None appears.
Third,
ಇಲ್ಲ, not.
Third unrepresented.
even notice has also not gone.
Was not. So
Notice are put.
Ratna Shogi Matta for respond number 3. Issue no emergent notice to respond number 4.
Three ಮಾಡಿ.
So ಅಲ್ಲಿ respond number 4 ಅಂತ ಹೇಳಿದ್ದೀನಿ ತಾನೆ, that is the private yes 30th
ಅಲ್ಲ 30th ಆಗಲ್ಲ sir. First week of November, I'll get
only to
this.
secure information, sir.
So I'm not, because I have to file the objection also.
ಆಯ್ತು 5th of November.
Please.
ಕೊಡ್ತೀನಿ. ಮಾಡಿಸಿ.
ಕೊಟ್ಬಿಡಿ.
ಆ ಕಾಪಿನೇ ಕೊಡಿ.
Serial number 4040 Ratna.
On the next date of hearing, you have to file it along with a memo.
Yes.
ಇವಾಗ ಅವ್ರ ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ.
Sir,
ಅವ್ರ ಕಾಪಿ ಕೊಡಿ, because he has to get the information. You have to give it today itself.
yes, along with member today.
Yes.
Manor, single to the
Serial number 4040 Ratna and Shoyagi.
Please, please. I have one of CD in filing, 7 days delay in filing, I 2 for stay, man.
Learned government advocate takes notice for response number 1 to 3.
Please.
Learned counsel Sri Sangana Baswa B. Patil has entered appearance for respond number 4. Yes.
My lords, in this case, my lords, the writ petitioner had challenged the annexure B, issued the
Yes.
notification calling
There
for.
has been a direction that they should ensure that minimum of 500
Yes,
cards
yes, my lords.
should be available with you.
Yes, my lords.
Ah.
But unless it is passed, my lord, they can't, it is not, my lord. As per rule 11(2), my lords, there must be minimum 500 card holders for the each fair file shop. And if the another two shops were permitted, my lord, it will not survive. The rule 11(2) of the rules.
One submission, my lord. In this case, my lord, your lordship has granted interim order before the single bench, my lord, on 29th of 2022, my lord. ನೀವೇ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀರಿ ಈ ಕೇಸಲ್ಲಿ.
ಇದರಲ್ಲಿ
interim order ನೀವೇ ಕೊಟ್ಟಿದ್ದೀರಿ ಸ್ವಾಮಿ ಈ ಕೇಸಲ್ಲಿ.
Petition ದಲ್ಲಿ you lordship only granted the interim order ಅಂತ ಹೇಳಿ.
Interim order.
Interim order. Final
Anyway,
order.
Final order was not passed by
Not a
me.
final order, it's only.
That has merged in.
Yes.
Yes.
Last may kindly see that as per the notification, my lord, impugned notification challenge before the learned single judge, my lord, that they issued to grant another 2 more shops in the same village
Yes.
for 1,200 card holders.
Yes.
My lords, as per this rule 11(2), last may kindly see rule 11(2) of the control rules, my lord, 2016.
Shall not be less than 500.
Yes, my lords.
For a fair price depot.
Yes, ma'am.
In a rural area and
Yeah.
not less than 800.
In the
for
urban.
fair price depot in the urban area.
Provided that the authorized authority may have reasons to be recorded in writing, relax the limit up to the 100 cards for fair price
Yes.
depot in rural area. In this case, my lord, 1,200 card holders in the said village.
Huh?
1,200 card holders.
1,200?
200 card holders
Ah.
in the said village, my lord. You already, total number of card holders, 1,200. Already petitioner shop is there. Now they are issued notification, another 2 shops. If that is allowed, my lord, then it will contrary to the rule 11(2).
How it will be contrary?
And each fair price gave 500 back minimum.
Huh?
Minimum 500.
So, ಅವ್ರಿಗೆ ಬರೋದಿಲ್ಲ. The last of them, whoever has been allotted, he will not get 500.
Unless it is modified.
ಅವಾಗ ಅವರೇ ನಮ್ಗೆ ಆಗೋದಿಲ್ಲ ಇದು ಬೇಡ ಅಂತ ಡ್ರಾಪ್ ಮಾಡ್ತಾರೆ.
ಅದರಲ್ಲಿ another 2 shops.
But your interest is protected by the order of the learned single judge.
Yes,
saying that minimum 500 shall be ensured will be in your fair price shop.
Unless it is that notification is modified, my lord, then it is very different.
Where is the need? We don't see any such requirement.
ಇದರಲ್ಲಿ in another 2 shops ಅದನ್ನ modify ಆಗದೆ ಇದ್ರೆ that is very different.
What do you say about the proviso?
Proviso, my lord, that is minimum 500 card.
ಓದಿ ಮೇಡಮ್ ಇನ್ನೊಂದ್ಸರಿ proviso.
Yes, ma'am. Provided that the authorized authority may, for reasons to be recorded in writing, relax the limit up to 100 cards for the fair price depot rural area. If fair price depot is to serve the needs of the isolated settlement or layout where the number of ration cards is below the limit prescribed, that is special areas like tribals, tandas, and gollarhattis.
The 3.
The authorized authority may, if he considers it necessary, transfer ration cards from one fair price shop to another.
Yes.
On the request of ration card holders as result of reorganization of the jurisdictional area of the shop.
It meets all the requirements. Minimum of 500 should be with you.
Yes, minimum.
It is there. It is ensured even by the order of the learned single judge. How are you agreed?
My contention is unless that notification is modified or it is.
Modification?
ಅದರಲ್ಲಿ 2 shops ಗೆ ಪರ್ಮಿಷನ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ ನೋಟಿಫಿಕೇಶನ್. Last may kindly see the notification produced at Annexure B. Annexure B 28/9/2022. Same village ನಲ್ಲಿ another 2 ink page 37. One same village ಚಿಕ್ಕ ಗುತ್ತಿ ಲಿಂಗೇಶ್ವರ ಗುಡಿ ಹತ್ರ ಆಮೇಲೆ ಇನ್ನೊಂದು ಭೂತಾಳ ಸಿದ್ರು ಬರುತ್ತೆ. In addition to that, my lord, they have going to issue another 2 shops. This is the notification.
This is what you challenge before the learned single judge.
Yes, ma'am.
Yes. ನಿಮ್ದು ಸೇರಿ ಇವಾಗ 3 ಆಗುತ್ತೆ.
3 ಆಗುತ್ತೆ.
ಹೌದು.
It is contrary to that 11(2), rule 11(2). If that is granted, my lord, another 2 shops were granted.
The last one will suffer because there is only 1,200 according to you.
There is no such proviso.
So minimum 500 ಅಂತ ಎರಡಕ್ಕೆ ಇಟ್ರೆ last one will have only 200.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಆತರ ಪ್ರೊವಿಷನ್ ಇಲ್ಲ. First 200 if that is no card holders then they will not consider ಅಂತ ಅದರಲ್ಲಿ ಎಲ್ಲಿ ಪ್ರೊವಿಷನ್ ಇಲ್ಲ.
Copy 41, Sagamgoda V. Biradar.
In connected matter, my lords, I am undertake to file wakalat.
Second set of appeal memo.
My lord, earlier this petition was filed before the honorable single judge, my lord. It has been transferred since I'll file next statement.
2 weeks time is granted at the request of learned counsel for the appellant in MFA 202748 of 2023 to furnish the second set of the appeal memo and to take steps.
Already is on record, ma'am. Respondent number 4, they already filed petition.
2 and 3.
Yes, they are.
2 and 3 I am on.
2 and 3.
Yes, ma'am.
Yura?
Yes.
Nivena?
1 to 4, my lords, I am undertake to file.
And to take such steps ಅನ್ನೋದನ್ನ ತೆಗೆದಾಕಿ ಸ್ಟಾಪ್ ಹಾಕೊಂಡು learned counsel the Sanganagowda V. Biradar undertakes to appear for respondents number 2 and 3.
1 to 4.
1 to 4.
1 to 4 I am on.
1 to 4.
1 to 4. 1 to 4.
And 5-6 is already served, my lord.
Yaravaru 5, 6.
My lord, 5 is concerned, owner of the tractor, 6 is owner of the trailer, my trailer. Notices were served, my lord. They will place the expert.
Right. 1 to 4. Full stop.
In first matter, my name.
2 weeks time is granted to the learned counsel, Sri Biradar, to file wakalat.
Yes, my lord.
On behalf of response number 1 to 4.
My lord, in first matter, my name is kindly deleted and Aspali, SS Aspali is name.
Name, my name is short.
ಇದರಲ್ಲಿ MFA 2005-256 ಅಲ್ಲಿ office is directed to show the name of learned counsel to SS Aspalli in the place of learned counsel Srimati Sangeeta Bhadrashetty.
Yes. Respond number 4 and 5 and 6 may be placed ex parte. Notices were served.
ಆಯ್ತು, ನಾವೇನ್ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹೇಳೋದ್ ಬೇಕಿಲ್ಲ ಅದು. ಎಸ್.
Seal number 42, Subhas Vallapur.
Appeal by insurance company. Appeal by insurance. But here, the extent is between the motorcycle and the truck trailer monots. The truck trailer monots which carries that containers, ship containers. That was not insured.
Will deposit 50%?
Yes.
Yes.
On deposit, claimants may be permitted to withdraw. Subject
sir.
to, my lords,
Yeah. Our specific
Learned
contention is,
counsel
my lords, that it was not insured.
Has entered appearance for response number 1 to 3.
Hello, 1 to 4, sir.
1 to 4. Issue notice to respond number 5 and 6. Learned counsel for appellant is directed to serve copy of the appeal memo along with annex. Next para. There shall be an ad interim order of stay of the impugned judgment and award in MVC 299 of 2018 on the file of the MACT number 7, Vijayapura till the Vijayapura, subject to the appellant depositing 50% of the award amount before the tribunal within a period of 6 weeks from today. Full stop. Liberty is also reserved to the claimants to seek withdrawal of the amount, which shall be subject to the final outcome of this appeal. Yes.
On, lords, I will also execute indemnity, lords.
ಅದ್ ಮಾಡೇ ಮಾಡ್ತಾರೆ.
ಅದನ್ನ ತಾವು ಬರೆದ್ರೆ ಇಲ್ಲ.
Without that, they won't give you.
Yes.
And upon furnishing necessary indemnity form.
Please.
Yes.
Seal number 43, Kausalgi Chandrakant Lakshman. Seal number 43.
Only one respondent refer to local any KSRC.
Any KRTC.
Bhadrashetty.
Learned counsel Srimati Sangeeta Bhadrashetty, who is present in the court, takes notice for the respondent, any KRTC, Gulbarga. Stop. Learned counsel for the appellant is directed to serve copy of the appeal memo along with annexures on the learned counsel for the respondent. Next para. The matter stands referred to the local.
Yes, please.
Seal number 44, SSS Dikshit.
This is a petition of G and WC lordships, wherein we had sought for appointment of guardian and permission to sell the property on the ground that the husband of the appellant and
No interim prayer.
No interim prayer, lordships.
Issue notice to the respondents.
Your lordships, it is government.
Government?
Yes, your lordships. Because there is no.
CNWC.
Yes, your lordships. There is no other person who is government state of Karnataka. Deputy Commissioner Vijay. Copy is not sorry. I will serve the copy, your lordships. There is no other person who is objecting the same.
Learned government advocate takes notice for the respondent. Learned counsel for the appellant is directed to serve 2 sets of copies of the appeal memo along with annexures from the learned government advocate.
Any date may be fixed for the next hearing so that it doesn't, it is not.
ಅದು ಅಷ್ಟು ಸುಲಭ ಅಲ್ಲ ಸರ್. ಅವರು he has to secure information.
Any further date at least.
Yes,
please.
Seal number 45, Subhas Mallapur.
Insurance appeal one also. Two grounds for us. No DL and the vehicle has been falsely implicated. The complaint is lodged after 3 days from the accident. And my lords, the driver of the insured vehicle was not having driving license. We have produced the endorsement of the RTO that no such license has been issued. And my lord, there is a 3 days delay in filing the complaint.
challenging liability.
Liability on the ground of false implication and my lord said no DL. No DL pay and recover agit, but a false implication. I'm ready to deposit.
Oh, so you're going to deposit 50%?
Yes, yes.
Issue notice to the respondents. Stop. In the meanwhile, there should be an ad interim order of stay. Same. MVC 2200 of 2014.
2200.
Before the third additional district and session judge, MACT 4, Vijayapura. Yes.
MVC number is 2200.
2200.
Yes.
Yes.
Final hearing matters. Seal number 46, GS Biradar.
Matters called out. There is no representation for the appellant. Released this matter on 12th of November.
Seal number 47, BD Angarki.
Same order. No representation for either of the parties.
Seal number 48, Prabhu B, DP Ambekar.
Yes.
I am for appellant.
Appellant.
My lord, I request your lordship, my lord, on 14/7/2023. By this court, my lord, my order dated 14/7/2023 has made it clear, directing the KHB Housing Board to produce the documents with regard to the land in dispute, whether entire land is formed into layout plan or it is vacant.
Kindly pass our
Up
senior.
till now, report is not produced, sir.
Kindly pass.
14/7/23 order is not complied.
Senior will appear in VC.
Already, our there was some direction for you to furnish information. Have you furnished it or not?
No, sir. Matter was heard.
That order was passed in July 2023. Why have you not furnished that information?
So senior will appear in VC. Kindly pass. Penal advocate Ashok Karan.
Information ಕೊಟ್ಟಿದ್ದೀರೋ ಇಲ್ವೋ ಅಂತ ಕೇಳ್ತಾ ಇದೀನಿ ರೀ. ಅದಕ್ಕೂ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಬರ್ಬೇಕಾ?
You will appear in VC.
You are the advocate on record? Who is the advocate on record?
Shokar College.
Says Mamadapur for respondent number 4.
Karnataka Housing Board ಯಾರ್ರೀ?
Mamdapur and
Mamdapur and Ashokar College.
Mamdapur. learned counsel for the appellant in RFA 716 of 2015 has pointed out to order dated 14/7/2023, whereby it was directed that the respondent, Commissioner of the Karnataka Housing Board, shall furnish information regarding the details of the layout formed by the board and allotments if made, comma, then details of the list of allottees. Full stop. Despite such directions being issued on 14/7/2023, comma, till date, no information is placed on record. Full stop. Yen information elri adu? Where is the information as was directed on 14/7/2023?
Illa, I have I shall furnish along with the memo. I have secured those documents. I will furnish.
Next para. Learned counsel Sri S.S. Mamdapur, appearing on behalf of the Housing Board, submits that the information is ready and the same will be filed by next week. Stop.
Your Lordship,
Copy of the same shall also be served on the learned counsel for the appellants.
Appellant.
Next para. Release this matter
Milord,
on
one submission. I am for cross objector, Milord. Connected cross objection. I have filed memo along with documents furnished by Housing Board itself, Milord. Memo dated, it is shown in the card list. Memo filed on 10/9/2024.
Hakidara.
ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಅವ್ರು ಹಾಕಿದ್ದಾರೆ.
I myself have filed.
I will also note those documents which I have
That
secured.
information,
I will place it before the.
it was for you to place it.
Yes.
How is it that information is already?
ಅವ್ರು ರೈಟ್ ಟು ಇನ್ಫಾರ್ಮೇಶನ್ ಆಕ್ಟ್ ಕೆಳಗಡೆ ಅಪ್ಲೈ ಮಾಡಿ ತಗೊಂಡಿದ್ದಾರೆ ಕಾಣ್ತಾವ.
Ad beda. That is not in. Release this matter on 11th of November.
Please.
By next week, you will have to furnish the information.
ನಾಳೆ
to the
ಅವ್ರಿಗೆ
office.
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ ನಾಳೆ ಫೈಲ್ ಮಾಡಿ.
Yes.
Seal number 49, additional SPP. 49, additional SPP.
Yes.
Matter is called out. There is no representation for the respondent. Full stop. Release this matter on 14th of November. Please.
Seal number 50, 50, Rajendra C. Desai, Shivashankar H. Manur.
Matter is called out. There is no representation for the appellants.
One appeal I am appearing on behalf of Ashok Karkal.
So Ashok Kalyan Shetty.
Our colleagues. We have taken.
In criminal appeal number 20009 of 2016
Hello, one.
and
1584.
2000143 of 2015.
Mallards.
Full stop. Release this matter, release these matters on 14th of November. Please.
Seal number 51, Avinash A. Uplamkar.
No representation for the appellant. Huh?
Seal number 52.
15th of November. 15th of November. The last one.
Seal number 52, MM Patil, SM Patil.
For the appellates, my lord. See the plaintiff appeal. Being agreed by the judge on number 8.
You are the contesting respondent?
No, my lords, actually the judgment and this judgment and decree is under order 8 rule 10 CPC. Not got any opportunity to file and return statement. Return statement ಹಾಕ್ಲಿಕ್ಕೆ ನಂಗೆ ಅವಕಾಶ ಸಿಕ್ಕಿಲ್ಲ ಸರ್.
Return statement?
Sir, this judgment and decree which has been passed in this OAS is under order 8 rule 10 CPC, my lords.
Ah,
I have not been filed in WS before the lower court as being seeking for a remand of this matter.
who is seeking remand of the matter?
I am seeking.
You are.
Please.
You are the respondent.
Respondent number 8.
Huh?
8. Respondent number 8, my lords.
Ah. How are you seeking remand of the matter?
My lords, even I am one of the family member of the.
ಹೌದ್ರಿ ನೀವೇನ್ ಅಪೀಲ್ ಹಾಕಿಲ್ವಲ್ಲ?
Please.
Huh? I am not able to understand, sir. What you are trying to submit, I am not able to understand. You are not the appellant.
No, my lords, I am not the appellant.
Then how are you saying that I am seeking remand of the matter?
No, my lords. There is one ruling, my lords, on their behalf of. Already I have been submitted before the court.
Are you saying that the appeal may be allowed?
Yes, my lords.
And the matter should be remanded?
Please, please.
That is your submission.
Please, my lords.
My appeal is entirely different, my lord. My relief sought in the present appeal. It is totally different. He cannot come into my appeal and seek.
Suit for
such prayer.
partition.
Yes, please.
Huh? How is it that all of them have remained absent except respondent number 8?
Before the trial
ಅಲ್ಲಿ
court,
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಲ್ಲ ಕಂಟೆಸ್ಟ್ ಮಾಡ್ಲಿಲ್ವಾ?
respondent number 1 appeared and filed WS and led her evidence, my lords. Respondent number 2, 10 to 12 appeared through counsel but did not file WS. Respondent number 3 to 6 filed WS but did not lead their evidence. Respondent number 7 to 9 and 13 to 15 were placed ex parte.
You are the plaintiff?
I am the plaintiff before the trial court. The suit has been partly decreed. And claim in respect of one of the suit item has been dismissed. Being aggrieved by the same, the present appeal has been
only regarding one item.
One item.
You are aggrieved only of that.
Yes. My appeal is also restricted.
What is your
to
submission?
the claim?
My lords.
You have not preferred any appeal, sir. How can you say you are seeking remand of the matter?
My lords, as pertaining to that, I am relying upon this ruling. The Honorable Court, please to. Sir.
All right. Yes, sir, we have understood.
Please.
But you are not the appellant before the court.
Yes, sir, I do.
Why should we ask you whether the matter is to be remanded? The judgment may be correct. Normally,
please,
if written statement is not filed,
please,
the matter should be remanded to enable the parties to file written statement, lead evidence, and thereafter the matter should be decided on merits. You have not filed an appeal. You have not even filed a cross objection. Nothing. And how are you making submission that the matter may be remanded?
Lords, in that case, a date may kindly be fixed. I will file an objection as well.
Madi.
The matter was part heard and the matter has been released, my lords, by the earlier bench.
We have to rehear the entire thing now. We have to rehear.
I'm ready for arguments. My arguments may be heard because the matter pertains to 2016.
2016. When was this judgment passed?
In the year 2016, madams.
What were you doing all this year? And you're making submission, remand the matter.
The trial court, my lords.
How are you going to explain the delay? There will be a regular appeal, sir. How are you going to explain the delay? Why the others are not appearing?
I don't know, my lords. That as pertaining to that, I don't know.
Re, ivala partition suit re, all family members.
ಇಲ್ಲ ಇಲ್ಲ ಸರ್, ಅವರು ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಟು ಅವರು ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ ಸರ್. ಅವ್ರ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಅವ್ರಿಗೆ ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ. ಬಟ್ ನನ್ನ ಇದಕ್ಕೆ ಅವ್ರಿಗೆ ಅಪಿಯರ್ ಆಗಿಲ್ಲ ಸರ್.
The appellants and respondent number 1 to 7 are constitute a family, my lords. Respondent number 8 to 15 are unknown to the family as well as to the suit properties. But their names are reflected in our
Purchasers,
They are not purchasers, my lord.
Then
they have managed to enter their names in the revenue records. Therefore,
without title.
Without title. Therefore, a suit for partition and separate position was filed, including the respondent number 8 to 15. Before the trial court, none appeared and filed written statement. Fee were placed even ex parte. They have not challenged the said order till today.
And despite that, one item of the suitable property,
one item property is to be
ಹೇಳಿದ್ದಾರೆ?
decreed. Holding that during the lifetime of the father of these appellants, he gifted half portion of that item to his wife. And subsequently, the wife gifts it to the second respondent, her mother, her elder daughter. The said gift has not been proved before the trial court. The very contention.
Therefore, that one item has been left out.
Yes, that
lords,
item against
one submission, my lords. My lords, this appellant plaintiff have been suppressed the true fact and got filed as suit, my lords. By suppressing the true facts, this appellant had been filed as plaintiff suit.
How can you make all this submissions, sir? You are not the appellant before the court.
No, my lords, just for where I am standing in this appeal, I want to explain this to honorable court members.
See, you have not participated in the proceedings.
No, my lords, I have not participated. I have been placed in ex parte.
And the contention is that you are not a member of the family.
He says, my lords.
Yeah.
But in fact, I am the member of the family. I am the member of the family.
Where is the genealogical tree?
Page number 11 of
lords,
the
as pertaining to his genealogy,
page number 11 of
he
the
had been suppressed the material fact and he had been shown that. In fact, the grandfather of this, the father of this Basava Bhavasa has got two sons by name Hussain Sab and Bhavasa.
Why did you not contest the matter then? And you have not filed an appeal now. How can we hear this kind of a submission at your hands? He is aggrieved that one item of the property is not given. So we have to hear the appellant. That is how the law works.
I do.
Then 2016 ಅಲ್ಲಿ ಹಾಕಿರೋದು RFA ಅವರು. We are in 2024 now. 10 years ಆಗಿದೆ. And now you are saying, no, please demand the matter. How?
The grounds for preferring the appeal, my lords. The ground for preferring the appeals is that
we will fix a date next week. We will hear this matter and dispose. List this matter for final hearing on 12th of November. Yes. All this is not going to help you, no. You have not filed any appeal.
Seal number 53, additional SPP.
State appeal, my lords, it's 498 and it's.
Sanjay Patil.
Sanjay Patil for respondent number 13415.
Matter is called out. There is no representation for the respondent. Release this matter on 15th of November, please.
Seal number 54, Sudhir Kulkarni.
Matter is called out. Is there any respondents?
Yes. Lord, in this case,
MC case.
MC. See the appeal filed by the wife. Before the family court, he filed petition under section 9 conjugal rights.
Who had filed the matrimonial case?
Yes.
Wife.
Wife. conjugal rights under section 9 of Hindu Marriage Act,
Restitution of conjugal rights.
wherein the husband made counterclaim regarding the divorce. Divorce is allowed, my petition is dismissed. One submission, this court passed the interim order for payment of maintenance amount. He is the professor working in government college. Last 2.5 years, he is not making any payment.
He is not paid.
Paid.
Maintenance.
40 lakh.
Is it correct?
He has taken car, enjoying the everything.
I will verify, sir, one thing, it has not paid. He has now, after the appeal period is over, the respondent has performed a second marriage. Your Lordship.
During the
Married
pendency of this appeal, he married. During the pendency of this appeal, before issuing notice to him, we have communicated by telephone, by issuing message.
ಏನಂತ ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಿದೀರಾ ಅಂತ?
ಅಪೀಲ್ ಮಾಡಿದ್ದೀವಿ, ನೀನು ಮದುವೆ ಮಾಡ್ಕೋಬೇಡ ಅಂತ ಒಂದು ಮೆಸೇಜ್ ಕಳಿಸಿದ್ವಿ, ಅವ್ರಿಗೆ ಮುಟ್ಟಿದೆ.
ಅಲ್ಲ, ಇಲ್ಲಿ ಬಂದು ಒಂದು ಆರ್ಡರ್ ಮಾಡಿಸ್ಕೊಳ್ಳೋ ಬದಲು ನೀವು ಅವ್ರಿಗೆ ಹೋಗಿ ಇನ್ಫಾರ್ಮೇಶನ್ ಕೊಟ್ರೆ ಏನ್ ಪ್ರಯೋಜನ?
Just communicating.
These kind of matters, correct. Advocates should ensure that an appropriate order is passed by the court.
Immediately file ಆದ ತಕ್ಷಣ ಮಾಡಿದ್ವಿ.
There is no delay.
Delay ಇತ್ತು ಅದರಲ್ಲಿ.
Delay.
35 days delay ಇತ್ತು.
Delay is there.
35 days. The delay was condoned, appeal is admitted now.
What is the use, sir? In the interregnum, he is married now.
ಹೇಳಿದ್ದೀನಿ ಪಾರ್ಟಿಗೆ ಹೇಳಿದ್ದೀನಿ ದೇವಟ್ಟು.
Many of the cases are like this now. If you are not careful in these matters, this is what is going to happen. Our hands will be tied. Learned counsel for the appellant submits that the respondent has not complied with ಯಾವ್ದದು, which order?
Interim order on 1025.
Six one 2000. Yeah. Order dated 6/1/2021, whereby it was directed that the respondent husband shall pay maintenance pendant light at the rate of ₹15,000 per month to the appellant from the date of petition, and a lump sum of ₹20,000 towards the litigation expenses. Full stop. Yes.
Sir, I will communicate and them to pay the amount, Your Lordship.
Next para. The respondent husband is hereby called upon to comply with the said order dated 6/1/2021 within a period of 4 weeks from today.
Yes.
Stop. Release this matter. On 25th of November.
Seal number 55, Jadege Kaila C.
Yes.
Basaraj Reddy for respondent.
I appear for respondent 2 to C. 2 to 5.
You have also filed an appeal.
No, my lords, in both the cases, I am appearing for the respondent. In both the matters, I appear for the respondent. First matter, I appear for respondent 2 to 5. The second matter, I appear for,
Angarki.
yes, my lords, for 4, 10 to 12.
So Basaraj Reddy is not here.
Basaraj Reddy. Connected appeal RF.
Matter is called out. There is no representation for the appellant in RFA 20029 of 2017. Full stop. Release this matter on 14th of November.
Seal number 56, VD Angarki.
Here for the appellant, my lords, parties have settled the matter. Parties settled, I appear for the appellant, my lords. Parties have settled the matter, my lords.
Settle the matter.
Settled. The date may be given after Deepavali. After Deepavali, any one date may be given. Learned counsel for the appellant submits that the parties have settled the matter. Full stop. However, want to file a joint memo. Compress petition would be filed.
Petition we are.
However, however, the learned counsels on both the sides seek for a short accommodation to file a compromise petition. Full stop. Accordingly, release this matter on 6th of November.
After 15th,
After 15th.
because some landed properties are there.
uh,
And we have to demarcate the shares in the map also, map.
On 19th of November.
Applies, much applies.
Alright.
Seal number 57, Hanumantrai Sindol.
Matter is called out. There is no representation for either of the parties. Release this matter on 13th of November.
Seal number 58, Ullappa Yerur.
But this is an appeal against the dismissal of petition for divorce. On the sole ground that the allegations are not proved, my petition is dismissed. Against this, my lord, I am before this honorable court.
Respondent has remained.
I have taken paper publication and respondent number 2 did not appear, 1 also not appeared. I have filed the mobile phone conversation exhibit P5. Exhibit P4 is audio. Learned judge did not believe all those things and dismissed my petition.
Who is
Paramar. Second respondent is her Paramar. Second respondent is her Paramar.
He did not appear before the. Yes. Matter was contested by respondent number 1.
Yes. Yes. She led her evidence before the family court. She contested.
Oathbody from the reasoning portion, paragraph number 10.
Point number 1. The petitioner in support of his case got himself examined as PW1 and examined the 2 witnesses on his behalf. as PW 2 and 3 and mark the documents as per annexure P1 to P5. Exhibit P1 is the marriage invitation card, goes to show that marriage of petitioner and respondent number 1 was solemnized on 30th April 2015.
Point number 1 is regarding whether petitioner has made out sufficient grounds. I suppose marriage is not disputed.
No, not
All-
disputed.
Yes,
Marriage not disputed.
yes.
11. On the other hand, the respondent number 1 got examined herself as RW1 and got examined one witness on her behalf as RW2, but respondent number 1 has not led any documentary evidence. I have perused the petition arguments and objection and also gone through the rival contention and allegations made against each other and also perused the oral and documentary evidence led by the petitioner and also the case laws relied by the counsel for the respondent number 1. The petitioner in his petition has averred that the respondent had illicit relation with respondent number 2. To prove this aspect, except PW1, no other witnesses of petitioner number PW2 and 3 have deposed anything about the chastity of respondent number 1 because of the reasons that PW2 in his cross-examination of opposite counsel has deposed that ಗೋವಾದಲ್ಲಿ ಅವರು 2 ವರ್ಷಗಳ ಕಾಲ ಇದ್ದರು. ನಂತರ ಕಮಲಾಪುರಕ್ಕೆ ಬಂದರು. ಗೋವಾದಲ್ಲಿ ಏನಾಗಿತ್ತು ಅಂದರೆ ಗೊತ್ತಿಲ್ಲ. And PW3 in his cross-examination of opposite counsel has deposed that ಗೋವಾದಲ್ಲಿ ಮೊಬೈಲ್ ಮೂಲಕ ಎದುರುದಾರಳು ಒಬ್ಬ ಹನುಮಂತನಿಗೆ ಮಾತನಾಡುತ್ತಿದ್ದಳು ಎಂದು ಹೇಳಿದರು. ಮಾತನಾಡುವಾಗ ನಾನು ಇರಲಿಲ್ಲ. When such being so, the evidence of PW2 and 3 are fatal to the case of petitioner as they have not witnessed nor heard anything about the incident pleaded by the petitioner in his petition with regard to respondent number 2. When such being so, based upon the evidence of only PW1, court cannot just come to the conclusion and grant the decree of divorce as prayed by him. Moreover, the petitioner has filed the case against the respondent number 2, Hanumanta, but in spite of sufficient time given, the petitioner has not chosen to take steps against the respondent number 2. Hence, the case against him has been dismissed on. Itself goes to show that the petitioner has not approached this court in a proper manner. Further,
So
petitioner
the case has
averred
been
that
dismissed again respondent number 2.
yes,
Not that he did not appear.
steps taken, notices taken, not served. We did not take any steps further.
ಹಂಗಿದ್ರೆ ಏನಾಗ್ಬೇಕು?
Ah,
He should be placed ex parte saying that he sufficiently served. But that is not so. The
notice-
case has been dismissed against respondent number 2.
Yes, no
Yes.
matter, no matter. Further, the petitioner has averred that the respondent number had illicit relation with the respondent number 2. And in this regard, he has recorded the voice of respondent number 1 and 2. And to that effect, the petitioner has also produced the document of conversation happened between his wife and respondent number 1 and other person. But on careful perusal of exhibit P5, the said document does not bear any phone call number and also it does not prove that this respondent number only has spoken to the respondent number 2. And further, it also does not prove between whom the said conversation happened. And to that effect, there is also no any certificate from the concerned authority to show that the said conversation happened only between this respondent number 1 and respondent number 2. Moreover, the petitioner has not obtained any permission from the concerned police authority to record the voice of unknown persons. As such, based on exhibit P5, only the court cannot come to the just conclusion that the respondent number 1 has illicit relationship with the respondent number 2. Moreover, nothing is forthcoming from the mouth of PW2 and 3 and RW1 and 2 prove the allegations made by the petitioner in respect of illicit relation of respondent number 1 with the respondent number 2. Under the circumstances, the court cannot come to the conclusion based on the documents laid upon by the petitioner that the petitioner has made out sufficient grounds to grant decree of divorce. As such, I opine that petitioner has filed this petition based only on the suspicion on the respondent number 1 regarding her chastity which is not proved by him in this case. Further, I am of the opinion that the petitioner has not made out enough grounds for grant of decree of divorce, and I am of the conclusion that to that extent the arguments addressed by the counsel for respondent number 1 holds good, and the case laws relied by the counsel for respondent number 1 regarding this plea again is baseless. The learned matrimonial court has rightly come to the conclusion that the mere suspicion of the husband cannot be proof of adultery, especially when the appellant had not seen the respondent number in the company of any male member, nor he could name anyone, etc. are squarely applicable to the facts of the present case on hand. So also the PW1 in his cross-examination opposite counsel has deposed that ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ನನ್ನ ಮತ್ತು ಕುಟುಂಬದ ಸದಸ್ಯರ ಮೇಲೆ ಒಂದು ವರದಕ್ಷಿಣೆ ಕಿರುಕುಳ ಪ್ರಕರಣವನ್ನು ಮಾಡಿದ್ದಾರೆ ಎಂದರೆ ಸರಿ. And such being deposed by the PW1 in his cross-examination, I am of the opinion that only to avoid the criminal case and due to suspicion on respondent number 1, he has filed this baseless petition. So also the respondent number 1 has denied all the allegations made with the petitioner against her in her objection. Under all above attending circumstances of the case, I am of the opinion that petitioner has not made out sufficient grounds to grant degree of divorce as he sought in his petition. Hence, at the time of dismissing the petition, it is better to impose cost on the baseless petition. Therefore, I answer point number 1 in the negative.
Really?
This is similar to exhibit P5 is the
Other. It has been considered, but it has not been accepted.
And audio is also there at exhibit. Exhibit P4.
How do you prove?
That is the
If,
only.
if there is an audio recording in law, how do you prove it?
And the phone number, Lord, is given. Husband's phone number and the respondent number 2's telephone number. You see the conversation.
Section 65B ಕೆಳಗಡೆ Evidence Act Section 65B ಕೆಳಗಡೆ you are required to get a certificate from the expert saying, yes, this is, I have examined the original mobile phone from which this transaction has taken place.
They are rustic villagers.
Allah, our irbodu, but law requires, this is how you are allowed to prove. Information on audio or video is required to be proved in a particular manner by getting a certificate. Avalla ಏನು ಆಗಿಲ್ಲ ಇದರಲ್ಲಿ.
Exhibit P4 ಮಾಡ್ತಾರೆ. I rely upon exhibit P4 and 5.
You will not be permitted to rely.
That is what
it is not an acceptable evidence.
That is what the trial court held.
So what is wrong? No, nothing wrong in the order. You had raised the ground of cruelty? 1 year.
Together we lived for 1 year, 6 months, 6 months in our village, 6 months at Goa. We went for eking out our livelihood.
You also had gone to Goa?
Both together, we went to Goa. There we lived. From there she has come to her parents' place and did not turn up. This is the story.
Yes, heard, reserved.
Seal number 59, Shivanand Patil.
Just for short accommodation. Short accommodation. At the request of learned counsel for the appellant, release this matter on 19th of November.
Earlier, there is a status quo order, notes it could be extended. Status quo order is there.
Is it being continued?
That was until next date of hearing.
Till next date of hearing on Vidya. ಅದಾದ್ಮೇಲೆ ಬಂದೇ ಇಲ್ವಾ ಮ್ಯಾಟ್ರ್?
Thereafter,
interim directions given on 11/7/2019 that the party shall maintain status quo as on the said date shall continue till the next date of hearing.
Seal number 60 Babu H Metagudda.
In this case, challenging negligence and also quantum. So for negligence is concerned, two vehicles is involved. One is lorry is parked. Rider of the two-wheeler dash to parked vehicle. In view of Supreme Court judgment and section 122, it is entire negligence is lorry driver. It's parked, my lord, without lightings, my lord. Only 50% is, my lord, negligence aspect decided, my lord, in 50% rider of the two-wheeler and 50%
Injury case,
my lord, injury case, my lord. Injury case and death case other.
for the claimant.
My lord, he is in the injury case, my lord. He is a pillion rider, my lord. Pillion rider, my lord. He's a pillion. Death ಇರ್ಬೋದು ಸ್ವಾಮಿ, ಬಟ್ ಇವತ್ತು ಪೋಸ್ಟ್ ಆಗಿಲ್ಲ. ಇದರಲ್ಲಿ ಸಿಂಗಲ್ ಜಜ್ಮೆಂಟ್.
ಇನ್ನೊಂದಿದೆಯಾ?
ಇನ್ನೊಂದು ಕನೆಕ್ಟ್
ಅದು ವೆರಿಫೈ ಮಾಡ್ಬೇಕು ಸ್ವಾಮಿ. ಬಟ್ ಇದ್ರ ಪ್ರಕಾರ ರೈಡರ್ ಡೆತ್ ಆಗಿದಾನೆ ಸ್ವಾಮಿ.
ವೆರಿಫೈ ಮೇಲೆ ಅದರ ಅಪೀಲ್ ಇದ್ರು
ಇದು ವೆರಿಫೈ ಮಾಡಬೇಕು ಸ್ವಾಮಿ ನಾನು. ಯಾಕಂದ್ರೆ ಇವತ್ತು ಇದು ಒಂದೇ ಪೋಸ್ಟ್ ಆಗಿದೆ.
ಬಟ್ ಈ ಜಜ್ಮೆಂಟ್ ಸಪರೇಟ್ ಆಗಿ ಬರ್ದಿದ್ದಾರೆ.
ಸಪರೇಟ್ ಇದೆ, ಅದಕ್ಕೆ
ಸಪರೇಟ್ ಆಗಿ ಬರ್ದಿದ್ದಾರೆ.
ಸಪರೇಟ್ ಇದೆ ಸ್ವಾಮಿ. ಇದರಲ್ಲಿ 50% ಆಲ್ಸೋ ಡಿಡಕ್ಷನ್ ಮಾಡಿದಾರೆ. ಅದು ಡಿಡಕ್ಷನ್ ಬರಲ್ಲ. ಈಸ್ ಕಮ್ಸ್ ಅಂಡರ್ ಕಂಪೋಸಿಟ್ ನೆಗ್ಲಿಜೆನ್ಸಿ. ಅದನ್ನು 50% ಡಿಡಕ್ಷನ್ ಮಾಡಿದ್ದಾರೆ ಕಾಂಪನ್ಸೇಷನ್.
ಅದ್ರದ್ದು ಅಪೀಲ್ ಇದೆಯಾ?
ನೋಡ್ಬೇಕು ಸರ್, ಅದಕ್ಕೆ ನಾನು ಐ ವಿಲ್ ಚೆಕ್ಅಪ್ ಮಾಡಿ ಒಂದೇ ಬಂದದೆ ಗೊತ್ತಾ.
ಅದು
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ವಿಲ್ ಚೆಕ್ಅಪ್ ಅಂಡ್ ಪೋಸ್ಟ್ ದ ಮ್ಯಾಟರ್.
ಇದರಲ್ಲಿ ಈಸ್ ಪಿಲಿಯನ್ ರೈಡರ್ ಮೇಲೆ ನೆಗ್ಲಿಜೆನ್ಸಿನೂ ಅದು ಕಾಂಪನ್ಸೇಷನ್ ಡಿಡಕ್ಷನ್ ಬರಲ್ಲ ಸರ್. ಕಾಂಪನ್ಸೇಷನ್ ಅವಾರ್ಡ್ ಮಾಡಿದ್ದು ಡಿಡಕ್ಷನ್ ಬರಲ್ಲ ಸ್ವಾಮಿ ಈ ಕೇಸಲ್ಲಿ. ಕಮ್ಸ್ ಎನಿ ವೆಹಿಕಲ್ ಮೇಲೆ ಕ್ಲೇಮ್ ಮಾಡಬಹುದು
ಫ್ರಮ್ either that party or this party.
ಅದನ್ನು ಡಿಡಕ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. ಅಂಡ್ ಮಿಲಾಡ್ ಈಸ್ ನೆಗ್ಲಿಜೆನ್ಸಿ ಮಿಲಾಡ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಪ್ರಕಾರ ಪಾರ್ಕ್ ವೆಹಿಕಲ್ ಬರುತ್ತೆ ಸೆಕ್ಷನ್ 122 ಅಂಡ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಪ್ರಕಾರ ಎಂಟೈರ್ ನೆಗ್ಲಿಜೆನ್ಸಿ ಅವ್ರದೇ ಬರುತ್ತೆ. ಇದ್ರ 50% ರೈಡರ್ ಆಫ್ ದ ಟೂ ವೀಲರ್ ಹಾಕಿದ್ದಾರೆ.
ರೆಡ್ಡಿ ಅವರೇ, 2015 ಜಜ್ಮೆಂಟ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ is relying upon where it says you are not the rider. This person is not the person who was driving.
That is there.
So therefore, directly there cannot be an allegation that there is negligence on his part. There may be negligence on the part of the driver. So that cannot be translated to this person. And he has the benefit of making the claim either against the owner of that vehicle or this vehicle.
That is law.
That is the submission.
That is the law. That is
Hangidre then the appeal has to be allowed.
ಇಲ್ಲ ಅಲೋನ್ ನೋಡೋಣ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಅದು ಇನ್ನೊಂದು ಬರ್ತದ
ಅದಕ್ಕೂ ಇದಕ್ಕೆ ಸಂಬಂಧ ಇಲ್ಲ. Even if it is there, since a separate judgment has been rendered and 50% is deducted towards negligence.
ಅದೇ ಅವ್ರ ಮೇಲೆ ಮಾಡಿ ಪೇನ್ ರಿಕವರ್ ಮಾಡಿ ಐ ಕ್ಯಾನ್ ರಿಕವರ್ ಫ್ರಮ್ ದಟ್ ವೆಹಿಕಲ್. ದಟ್ ಜಜ್ಮೆಂಟ್ ಈಸ್ ಲೈಕ್ ದಟ್ ಮೈ ಲಾರ್ಡ್. ಇಟ್ ಈಸ್ ನಾಟ್ ದಟ್ ಐ ಹ್ಯಾವ್ ಎ ರೈಟ್ ಟು ರಿಕವರ್ ಅಗೇನ್ಸ್ಟ್ that person and the insurer and the owner of the vehicle.
ಅದು ನೋಡ್ಕೊಂಡು ಬನ್ನಿ. We will decide this matter.
Yes sir.
Release this matter on 12th of November.
Passed over matters.
ನಮ್ದೇ ಇಲ್ಲೇ ಒಂದು ಜಜ್ಮೆಂಟ್ ತಾವು ಬರ್ದಿರಿ ಇಲ್ಲೇ ಒಂದು.
Passed over matters. Serial number 9, additional SPP.
ಈ 9 and 10 released this matter on 6th of November. ಎರಡೂನು
My lordships can small serial number 48 11ನೇ ತಾರೀಕಿಗೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರಿ, 12ನೇ ತಾರೀಕಿಗೆ instead of 11 it may be taken up on 12th. I have informed the other side also that I would be.
12th ಅಂತ ಮಾಡ್ಬಿಡ್ತೀವಿ.
Please.
Mention 482.